That's why, my lord, it was written, my lord. Thereafter, my lord, mentioning proper address, face representation was, my lord.
Where is your representation?
My lord, page number 30.
P7.
P7. My lord, mentioning proper address, my lord. 3. Assistant Engineer, Baripur, Highway Subdivision, PWD Roads, Directorate, Baripur, District South 24 Parganas, Kolkata, 700144.
So it was not with the Diamond Harbour Highway Division.
My lord.
It is now with the
Baripur.
Baripur Highway Subdivision.
Baripur Highway Division. Well, that is pending. That should be considered.
Let that presentation be considered.
Very good. Ashun, take
After
down.
giving hearing of the private
Both the
respondent as well as
Question.
Both, all in.
both the parties.
The
concern of SDO has requested the SP to supply force for demarcation of the position, my lord, on 24th of September. That has been
very good.
my lord. Yes. They have written to the video concern that they are ready and willing to provide the assistance. The date and time required to be fixed.
Demarcation 10 to 10-3 is already complete.
No, my lord. No, my lord. For the purpose of 10-1, they want assistance. The video wrote a letter to the SP.
লিখুন কি লিখলাম বলুন
my lord, kindly direct the petitioner to add him as a party. Otherwise, my lord, in future, my lord, there may be a difficulty, my lord. Kindly visualize.
No
my lord. And my lord, another thing, my lord, your lordship,
Is your lordship direction?
I have given the direction. It will be commented. What communication?
as your lordship.
He will prepare a
Direct.
communication.
My lord, get.
You collect the address of the jurisdictional PLRO
My lord,
and give him a
Fine.
copy along with a server copy of this one.
As your lordship.
grateful, my lord.
Jalpaiguri matter. It's a sense matter. Who is for the state?
Lordship, Mr. Tapan Kumar Mukherjee is appearing in this matter.
He was right here.
He's on legs in court number 4. I'm praying for short pass over, Lordship.
Let Mr. Mukherjee come.
Grateful, Lordship.
Call the next matter. Item number 2, Mohammad Omar Farooq. Who is for the petitioner, sir?
I am for the respondent 1 to 5 railways.
My lord, in this matter, my lord, what has happened, my lord? In the CS stage, I was, or my predecessors were settled by the railway authority. My lord, kindly come to page 25.
Give me a second, sir. It is সরিয়ে page number 25. Yes, sir.
My lord, on top, উপরিস্থিত সত্ত্বের ভারত সম্রাট, and my lord, পরস্পরের অংশ is 16 আনা, and রাজস্ব is নিষ্কর. My lord has got it. নিষ্কর.
Yes.
And my lord, অত্র সত্ত্বের বিবরণ ও দখলকারে under the heading of ইস্টার্ন রেলওয়ে কর্তৃক পরিত্যক্ত বি ক্লাস ভূমি দং কালু মন্ডল মালিয়াত মন্ডল সুবেজান মন্ডল such and such মন্ডলস, and on the right hand side অত্র সত্ত্বের শ্রেণী এবং বিশেষ নিয়ম অনুসারে লাখে রাজদার it's a one kind of a tenancy like korfa, like sutkhai bhagchashi, like borgadar. These are the tenancies, and this lakhe rajdar is the rent-free tenant under the Bharat Samrat. Then, my lord, kindly turn to the next page.
Yes.
These are the areas on the right hand side. Shotok, and total area was 6 acre 38 decimals were settled in favor of these people. Now, my lord, kindly turn to the next page.
Where
Page-
will get the 6 acres?
My lord, on the right hand side, my lord, at the bottom, 6 acre 38 decimals.
Yes.
Now, my lord, kindly turn to the next page.
Yes.
This is the Khatian of KB stage, Khanapuri Bujarat stage, not finally published. And on the right hand side, my lord, will find Rayat at the bottom, অত্র সত্ত্বের শ্রেণী এবং বিশেষ নিয়ম ও 13 কলম. On the 13th column, my lord, will find Rayat.
What is the nature of this document?
My lord, this is Khanapuri, this is a draft record of rights. Draft record of rights of land reforms, land reform settlement. Now, my lord, kindly come to the all next pages. All are the KB stages Khatian, and everywhere, my lord, will find Rayat. Everywhere Rayat. All consecutive LRRORs, my lord, will find Rayat. And now, my lord, kindly come to the page 37 after it is finally published.
Yes.
Page 37. My lord,
Yes.
this is the দাগের তথ্য, and my lord will find জমির মোট পরিমাণ 5.45 on top, and দাগ number is 5580, and the different riots
are coming under different khatiyans. These are all are LR khatiyans. Thank you. And it has got it.
Yes, sir.
Yes. Now, Malad, this Rayat has got the right of inheritance as also transferable right under Section 4 of the Land Reforms Act. They once they became the Rayat, they became the owner under Section 4 of Land Reforms Act. And they have a right to inherit, they have a right to transfer everything.
Yes.
May I place Section 4? If my lord has got,
I have, sir.
my entire chamber is drowned under the water, submerged. So I could not bring the even books.
So almost all the briefs and books have been
No, my lord, around half a feet from the ground level.
half.
Half.
So up to 5 feet.
No, I said from ground level, half a feet.
Half a feet. Why?
Yes.
Still underwater.
No, now it's clear.
Just substitute. Yes, sir.
Rights of a Rayat in respect of land subject to the other provisions of this act. A Rayat shall, on and after the commencement of this act, be the owner of his plot of land, and the plot of land shall be heritable and transferable. So Rayat became the owner and with the rights of transfer and inheritance in pursuant to Section 4. Now, my lord, kindly come to page 40 and 41 of my petition. 40, 41, 42.
Four zero, 41 and 42.
Yes, all of them. This is the finally published LRROR, and everywhere they have been described as Rayat. 40 on page 40 onwards till page 43.
These riots are the petitioners before this court.
Yes, either petitioners or their predecessors are the sorry,
Sir,
their
Successor in
successors in interest.
Yes, sir.
Now, my lord, on the next page, my lord, will find on 30th October, my lord, I'm sorry, page 46. I gave a representation before the ADM.
The disputed plot is 5580.
Yes.
What is the representation, sir?
My lord, at page 46. That Eastern Railway without, my lord has got it. That the plot being number such and such under Mauja Dhitara, jail number such and such, police station such and such is lying and situated along the eastern side of the Eastern Railway track. That the plot in issue is recorded in the CSROR in the column of person in possession being the B class. Well, a B class I have shown from the CS record of rights, there is a written B class. These are the plots during those times. Railway authority, irrigation authority, they used to settle in favor of the citizens, and in return they used to get the either rent or rent free to protect the land of irrigation as also to protect the land of railway for stopping the encroachment. So B class abundant land of Eastern India Railways, which is held by persons named therein as Lakhe Rajdar with specified respective shares thereof. That since then the persons named therein are in possession in respect of the suit subject plot and have been enjoying usufructs thereof without being interfered from any quarter whatsoever, that recently the Eastern Railway Authority, without following any process of acquisition, has been in a mood to encroach upon the subject plot by applying authoritative force. Well, the Eastern Railway says, no, in CS record, as per the CS record, we are the owner. So we have the right. The operation and interplay of West Bengal Estate Acquisition, as also the West Bengal Land Reforms Act, I have become the owner and I have the heritable right as also transferable right. That they have forgotten. So now they are constructing the railway track on my land without any proceedings.
Then what is your prayer?
To stop them, or either they pay the compensation to me, whatever land they are requiring, because this is a Rayati land, this is not the government land. Now I'll kindly come to prayer B, or in my representation, my lord will find, and I have been paying khajna after the land reforms, obviously. And my lord, kindly turn to the next page, page 48. As per my RTI information,
Give me a second, sir. Yes, sir.
my lord, kindly turn to the next page, my lord, at page 48. And this is as per my RTI query, the district authority has said, or Eastern Railway has replied, PIO, that as per available records, was not acquired from construction department of Eastern Railway.
You have made the Union of India party.
Yes.
So what is your prayer then?
Kindly come to page 20. The prayer B is showing show cause as to why and under which proceedings they are constructing over the referred Rayati plots. Then prayer C, we have requested my lord to pass an order, mandamus, to not to construct on that land. And then my lord, prayer D, that again mandamus, asking the railway authority to stop the illegal activity on my plot without following any due process of law under Land Acquisition Act.
What is your pleading that as to how you get the Rayati right?
Yes.
What is your pleading to that?
Kindly come to page 6, para 3, para 2 onwards. That from the settlement operation of CS, it appears that
Just a minute, sir, just a minute. I believe paragraph 10 is the appropriate also. Will you kindly place, sir?
Well,
Para 10 of your petition.
that your petitioners contend that since time immemorial the subject plot has been occupied and enjoyed the usufructs thereof by the persons named and recorded as Lakherajdar. In the CS settlement, the predecessor in interest vendors of the petitioners' name were recorded as Lakherajdar. In the course of time, the Lakherajdar holders became Rayat in later settlement, and also in the recent and current being LRROR, the petitioners have been upon payment of khajnas to the Land Revenue Department to the Government of West Bengal possessing and enjoying the plot of land without any interference and objection from any quarter whatsoever, including the Railway Authority. As on today, the petitioners acquired good right title and interest over the plot of land. My lord,
And
I
also
have,
acquire royalty title.
yes, I have also stated this few paragraphs and the interplay between Estate Acquisition Act, what happens. Well, kindly come to page 4. Paragraph 4, page 7. That KB operation, that is the Khanapuri Bujarat operation, culminated into finally published RSROR, in which the plot of land has been shown Rayati land against each possessor. The petitioners' names are recorded in the said ROR as Rayat, that too without any objection being raised by the Railway Authority. By conjoint effect of section 4 and 5 of the West Bengal Estate Acquisition Act, the land stood vested in favor of the state of West Bengal, and consequently the estate and rights of the intermediaries in the same estate got vested in the estate free funded encumbrances, and that's how the right of intermediaries has extinguished and title of the soil has become the right of the land.
Mr. Dhar, one thing I'm thinking that without declaring your right title and interest over,
I do not
so
require.
that-
I do not require, because from CS till LRROR till date, nobody has challenged my right.
title.
I have learned from my lord, when you have a threat in respect of your property regarding title, otherwise you file a suit for only permanent injunction before the court. You do not pray for title. All along, my lord, I have said there is no.
Whatever. good.
My instruction is that what this is Rampur Phat Murari third line expansion line. That has already been commissioned. And we have already stated that his land was not acquired by the railways. And we have also written to the state also to give the Moja map also to verify whether it falls under that line, expansion line. Third line of Rampur Phat Murari.
Their land are not going to be utilized.
According to us, it is not acquired. We have not acquired it.
No, you are not going to utilize them, those land.
No, my lord, it is not acquired. Already line has been commissioned, my lord. Third line,
Over their land.
not over the land. We have
My
stated
case
that
is
it
over
not-
my land.
We have stated that in RTI, we have stated that it's not acquired.
File a report.
That we can file, as your lordship pleases. We can file. We have already asked for the Moja map to verify that.
Then what is your stand?
We have to verify and then come before your lordship.
Yes, Mr. Potterwell?
My submission is on page 25, my lord. Here, my lord, the Dokholkar Sankipto Bharat Samrat, it has been written. And thereafter, my lord, just my below, Otto Satra Bibodharan Dokholkar, Eastern EI Railway Kortik Porityakta B class Bhumi. Therefore, my lord, the railway's name was recorded once in the record of right. And in that documents, my lord, next page, my lord, page 26, my lord, dag number, my lord,
No,
55.
if it be the stand of the railway authority,
Yes.
that the land is required to be acquired.
Yes.
And it has not been acquired.
That you have said.
Then what stand you can take?
No, if the land is not acquired, we have no role to play, my lord. If the railway, my lord, asks us to, my lord, acquire this land, my lord, then we shall take step for acquisition of that land. And as per their, my lord, page, my lord, my lord, 48, this land has
Is there
been
any
acquired.
scope to pass any interim order?
Yes, my lord. If my lord does not stop them,
Well, line has already been commissioned.
then my lord, kindly, my lord, that instruction I do not have.
I have-
If in the meantime,
No,
during
line
the
has
pen-
been commissioned over whose land? His land.
No, we are saying not we have not acquired his land. That we have said.
my lord,
that we
for
have
that
acquired.
demarcation is required with the help of Mr. Botobel's client. My lord, they would be in a better position because Moja map is lying with them. Well, in presence of the Union of India and in presence of us, well, let us find out whether the third line has gone through our land or not. If they are denying, they are not they are not saying my contention. They are not challenging anything about my contention that I have become the owner. Now they are disputing that not from that land I have taken any inch. So for that, identification is required.
So far as the demarcation is concerned, Rajati land could not be demarcated. There is no provision.
This subject matter. My lord, I'll put the petition on my lord. Wait, I'll take up the Jalpaiguri matter. Mr. Mukherjee has come. Apart from state, any other private respondents there?
Private respondent is there, my lord. He has refused service one.
Where is this AVW service?
But initially at the instance
Give
of
me a second, sir. You have sent it to courier service.
in the first writ petition, they appeared, my lord. It was at their instance, my lord. Thereafter, 3 writ petitions were filed, my lord. None, of the-
Siliguri Motels Limited,
my lord.
private limited.
My contention is that, my lord, I am occupying, my lord, plot number 222. And the private respondent, my lord, also, my lord, occupies this plot number 222, my lord. There is a suit pending between the petitioner and the private respondent. There are interim orders, my lord. Now they came up with a case that my possession is at plot number 215. Just in front of them, they have made construction. Just in front of that construction, my lord, I am occupying under plot number 222. They are also just behind me under plot number 222. My lord, they said that I am occupying
Your plot is 222.
my lord, 222.
Your petition is running business such and such in the exclusive ATO imported into RS plot number 222.
222, my
You are carrying on business in the name and style of Suresh Electronics.
lord.
Then what happens?
My lord, thereafter, my lord, suddenly a writ petition was filed at the instance of the private respondent, saying that I am encroaching upon plot number 215. My lord, the High Court directed, my lord, for an
215 is a Rayoti land.
Hardest plot,
215
hardest plot.
RS plot, that is, they say, my lord, that is within the Highways Act, my lord, the highway land. Thereafter, my lord, a writ petition was filed. A notice was issued to me, my lord. A writ petition was filed at my instance, that is WPA number 2414 of 2014. That was disposed of, my lord, directing that there should be a survey by the appropriate BLRO, but survey was conducted. Well, the one-page report was supplied to me, but the map annexed to the report was not supplied to me. I wrote them that you supply the map. No.
The report says you are encroacher.
Yes.
Thereafter, my lord, I filed a fresh writ petition saying that unless the map is given to me, the report does not help me in any manner. Subsequently, in the writ petition, my lord, the third writ petition, WPA number 2072, my lord.
The first report writ petition was at their instance.
As they are
Second writ petition was at your instance, with a prayer for giving you the map.
For the survey, my lord.
Map.
Survey and survey report. Survey report was given. Connected an annexed map was not supplied.
I understand.
I wrote them that you supply the annexed map. Nothing was done.
You filed the second writ petition.
Eviction order was passed. I filed
in a 10-3 proceeding.
My lord. I filed a writ petition, my lord, saying that this eviction order is bad inasmuch as papers were not supplied to me in adequate manner, my lord. My lord, that order, my lord, will find at page 175 of the writ petition, my lord. The eviction order was set aside, my lord. Furthermore, my lord, they simultaneously, my lord, issued another notice under the
1962 Act, my lord, although saying that is a 1964 Act, although saying that is a 1962 Act, that is Eviction of Unauthorized Occupants Act. My lord, the entire matter was considered by the Honorable Court, my lord, at page, writ petition order was passed, my lord, at page 175.
Put the beep now. Put the beep now. Beep now to the beep now to the never double the
Then what happens, sir?
Then, my lord, so far as the
No,
part
ultimately what order was passed?
my lord, they were directed to hand over the entire report as well as the sketch map, my lord, and liberty was granted, my lord, for
No, during hearing, a copy of the sketch map was handed over to Mr. Sen.
my lord, we were directed
The
within 10 days
petitioner is granted to leave further, leave to file further representation by 10 days, raising additional points. Revisit the issue.
revisit the
Who is
issue.
the respondent for is the SDO?
My lord,
Respondent for is the SDO or the assistant engineer?
my lord, assistant engineer. Assistant engineer, PWD, Shiliguri, subdivision.
Last
Shiliguri.
final order means it must be SDO. It cannot be assistant engineer.
My lord, be that
What is it now? What is your grievance then?
my lord, thereafter, my lord, I filed a reply, my lord, on the same within the time stipulated by this honorable court, my lord.
In a 10-3 proceeding.
My lord. Thereafter, my lord, I asked for some documents that my lord will find at page 193 on the same date, my lord.
Page 193.
Page 193. My lord, so far as the assistant, I asked the assistant engineer to supply the documents, as also, my lord, the person who conducted inquiry, because the person must be having such map, my lord, the demarcation map rather. Now, my lord will kindly come to page 200, my lord.
No, so far 193 to 195. What is this?
My lord, 195, my lord, this is the this was annexed. 196, my lord, that is
193 is your application under the RTI Act.
my lord, RTI Act, my lord.
What is your query?
Query is, my lord, that provide me the actual wide width, literally width, my lord, width of PWD Hill Court.
RS plot number such and such is encroached by 10 sod with tin set structure, and as per ROR, the aforesaid plot is recorded in the Public Works Department. So you don't want to move from that. That is your whole object.
No, my lord, I am not occupying, my lord. My only object is to prove.
Then why have filed Mr. Sen? Why have filed the instant writ petition?
My lord, I did not get the demarcation map, my lord. Thereafter, my lord will kind to
No, demarcation map was given to you at the time of hearing by the landed council.
My lord, demarcation map now. That was the survey map, sketch map. This is the demarcation map of the land, my lord. The two must tally, my lord, to evict me, my lord. Unless both the maps, the survey map, my lord, survey map prepared while conducting survey by the instance of the authorities, and the actual map, my lord, of the.
No, sir.
My lord.
In your writ petition in WPA 1468 of 2025, your grievance was that the copy of the sketch map, which has been prepared by the jurisdictional BLRO, was not given.
My lord.
Only report was given.
My lord.
Sketch map was given to you in court. Then what more grievance you are?
Sketch map has to be read with, my lord, this map, my lord, demarcation map of the hill cut road. That then the actual whether I am at all occupying, my lord, plot number 215, that has to be ascertained.
Moja map.
Moja map, demarcation of this highway. Demarcation highway must have a map, my lord. It has to be tallied with
No,
the
no,
highway
the
map.
sketch maps have to be, the sketch map was prepared.
Well.
Sketch map was prepared upon comparing the Moja map.
Well, that was my contention, is that is the reason, my lord, I called upon the person who surveyed and submitted the survey map, to provide me this information. He says information is not with me, information with some other person. My lord will kindly come to page 200. Page 200, who writes is that SPIO, Assistant Director and Officer in Charge, Shiliguri Municipal Corporation area. He is the person who has conducted the survey. He says it is submitted that an RTI has been filed. Upon examination, it is observed the subject matter pertains to Public Works Department that does not fall under the jurisdiction of the department. Therefore, the provisions of section 6(3) of the RTI Act, the application is being transferred to your office for furnishing the required information directly to the applicant. Malat, this information has not been supplied, and Malat, subsequently an hearing notice has been given, and they have given a go-by to the schedule directed by this honorable court. They cannot take the point that High Court has directed within for 4 weeks hearing has to be done. They have given notice of hearing after the 4 weeks have elapsed. Only my prayer before your lordship is, my lord, let this information be given and hearing be done. I have to
Which information?
information that I have, that is the provide me the actual width of PWD hill cut road, including footpath drain that is in front of RS plot number 222. And the also provide information from the middle of the road, both sides, junction point, fixed point, demarcation point. Our main, so far as the main contention is in my objection, my lord, will see, my lord, objection I have annexed, my lord. That is, my lord, objection page 187. The process of creating the purported sketch map on the face of it lacks transparency. The sketch map report is flawed and does not accurately represent the situation and potentially disputing the legality of the encroachment, and the said sketch map claiming isn't accurately reflect the land boundaries of plot number 215. That it is clear from the sketch map of demarcation report provided by the authority concerned is that they have not demarcated the said land of RS plot number such and such from any fixed point or demarcation point, and they prepared the sketch map without establishing clear boundaries of the said plot. The every survey work is required to be conducted based on fixed point, but in the present case, the same has not been done. The assistant director.
Adduce evidence to that effect. Before the SDO.
This
10(3) provides for recording of evidence. You adduce evidence.
This I will definitely adduce evidence. Provided give the map, it will be clear. If they give the information, it will be clear. Because it is all government document, Malat. It is not my document. That is the only point. Let them provide me the document and hearing be done. That is the prayer in the writ petition. Good, bad, indifferent, Malat, I have to face the hearing. Order was passed by the Honorable Court, my lord, will see on 28th of July 2025. And I was directed to give reply on 7th of, within 7th of August 2024. That I have done. I have asked for the documents on the same date itself. My lord, already 1 month have passed. Furthermore, my lord, there was a direction that within 4 weeks hearing should be done.
Who is the appropriate authority for giving it?
Like, according to the person who has conducted in survey and given report, my lord, that is the
The
my lord,
jurisdictional BLRO.
my lord, he should be having all papers, my lord. He is giving.
Yes, Mr. Mukherjee.
Mona, kindly see page 179, paragraph 17 of the Order of Justice Bhattacharya.
Huh.
Advance on behalf of the petitioner that the state authorities are running two parallel proceedings, one in terms of section 10 of the West Bengal House Act 64, another in terms of section 3 of the West Bengal Public Land Eviction of the 62, need not be detailed in view of the submission by the Land Advocate General. That only left upon the state authority to take recourse to section 10 of the West Bengal House Act 1964. Mona, kindly see the next page, page 181.
181.
181.
Yes.
20th December 24.
Yes, sir.
You want to kindly see RS plot number 215, total area 2.92, encroach area 00.86. Then classification path, encroach area is highlighted in the sketch map, encroach. Then when page 183. Encroached by 10 shops. Then Malad, kindly see page 184. 17th March 2025. This is to inform that as per Assistant Director Officer in charge of Siliguri Municipal Corporation, LR, Siliguri report, it has been found that you are encroaching in PWD land, RS plot number 215, therefore instructed to remove the encroachment of PWD land, subsection 1 of the House Act. You are required to remove the encroachment within 10 days from the date of that. Then can you see under section 10, if any order is passed, then section 10, subsection 4 appeal lies to the appellate authority.
No, order under 10.3 has been passed.
Passed. Kindly see the page 184.
No, it is a 10.1 notice.
10.1 notice. 10.1 notice. Then Mana, can you find that?
Then 10.2, 10.3, then 10.4.
Then Mana, can you see? 10. 10.1. If any person is found to have made an encroachment or any road or street, path or way or land is declared to be highway under subsection, makes an encroachment on a highway.
Page number 184 is a 10.1 notice.
10.1 notice. Then Mana, can you see subsection 4?
Where is that?
Of the 10, section 10, subsection 4. Available order.
I know that.
Then
But prior to that, an order is to be passed under 10.3. Whether that proceeding has been initiated or not.
that I at least that is no kindly see page 203. In compliance with the solemn order of the High Court mentioned above, you are requested to attend the hearing scheduled on 22nd September 83. As to your Siliguri, in connection with the method, you are requested to bring all the related support of your claim. Then he has challenged this. We should have to pass. When a 10.1 has been passed, final order to passed, he has given an hearing. He has not approached the authority concerned.
My lord, so far as the pages annexed at page 181 to 185, these are the pages that were, my lord, these were the documents that were all the correspondence were made prior to the writ petition filed earlier. That was taken care of, my lord, page 175, the order passed in WPA number 2075, order dated 28th of July 2025. What my learned senior friend is relying, my lord, that was prior to the passing of the order passed by the passed in the
But
earlier.
this order has not been set aside by the court.
But Mr. Sen,
My lord.
why the court will interfere with the notice into page number 203?
I am not, my lord, interfering in the sense, my lord will kindly consider the prayer, my lord, I have couched, my lord, in the writ petition. I have said, my lord, hearing be done, my lord, upon furnishing the documents I have prayed for. My lord, they have page 200, my lord, they have already referred the matter. Let the documents be given.
Where, show me where they have referred the matter.
My lord, page 200, my lord.
So,
Page 200, the RTI, my lord, upon examination, it is observed that the subject matter pertains to Public Works Department, roads, and does not fall under the jurisdiction of this department. Therefore, under provision 6.3, the application is being transferred to your office for furnishing the required information directly to the applicant. Let this information be given to me and hearing be done. Only
why it is necessary?
my lord, necessary, my lord, to show that, my lord, what is the exact extent of the PWD highway.
Sir,
My-
they have issued a notice upon you on the basis of the report, which is 181 to 183.
My lord, 181 to 183, my lord will consider it was the report.
181 to 183. This map was ultimately given to you.
Yes.
My lord,
Now you
after
give
the-
your evidence
my lord,
that you are not your encroachers. You are
my lord,
you are staying at
my-
your property.
my lord,
Just see
my lord,
section 10 proceeding C.
my lord.
আমাকে বই আনতে হবে, জেরক্স করতে হবে আমাকে। কোনোদিন পরিচয় করবি তো? আমি
10 3C, read place.
Such magistrate may, on receiving the application and after notice to the person responsible for encroachment and taking such evidence, if any, as he thinks fit, make an order authorizing the authority or officer to recover possession and remove the encroachment in question, and may, if necessary, direct the police to assist and enforce.
So, Mr. Sen, there is a provision for adducing evidence.
My lord,
You are to adduce evidence.
my lord,
You are to collect the document. You have
Well-
sought for, Mr. Sen,
Well-
you have sought for some document. It has not been supplied. That is an appealable order. Why this writ court will interfere?
no, my lord.
No,
that-
sir.
That is also the point, my lord. My lord, appealable order, my lord will now consider, my lord, the Right to Information Act, my lord.
Very good, sir.
My lord, unless, my lord, 83 is compliant.
Your grievance is that
My lord.
this map was not given to you.
No. Map.
Ultimately, it was given to court.
Ultimately was given.
Now you have
thereafter-
taken a new point
No.
that
My
participate.
lord, unless, my lord, I get the map, I cannot raise this point. I got the map. I have filed my objection. In the objection, I have also raised this
In
point.
10-3 proceeding, you call for ask the SDO to
No, no.
produce those documents.
Whereas my lord's observation that the RTI I have not got the this appealable order, my lord, so far as the appealable order will be
Just
after my lord 83 is complied, and my lord will kindly see, my lord, section 6.3, my lord. Once, my lord, where is the fallacy is, my lord? 6.3, my lord. What is the time frame, my lord, that has been given, my lord? 6.3 time frame has not been complied with. 6.3 time frame has not been complied with. It is within 5 days. They are holding the matter. Thereafter, after subsequent, my lord, much passage of time, my lord, they have forwarded it. 6.3, my lord. They have, my lord, in the page 200, my lord, it has been mentioned, section 6.3. 6.3 says within 5 days. My lord, now they are holding on. Subsequently, my lord, they have.
this is a plea for not moving from the encroachment.
No, my lord will kindly direct, my lord, giving of this document and hearing be done on within 5 days. I can't avoid the hearing, my lord. Fact remains, my lord, good, bad, indifferent, my lord. I cannot avoid the hearing. I have to participate. Only thing, my lord, I want this information that has not been given to me. And so far as the appealable provision under the Right to Information Act, it is not appealable unless, my lord, section 8 is compliant and section 6.3 is compliant. Complete violation of the act, my lord. That can be urged in writ petition. if they have either they have told me that you are not able to get the information, I will not give information. That is a different aspect of the matter. Here, my lord, they have not said that. They are holding on. And so far as the
Take the-
point raised by me, that can be urged, my lord,
The
after I
subject
give the
matter of the instant writ
My lord, person to your
But in this matter, I am appearing.
Just, yes. বাইশ তারিখ আজ কত তারিখ গো? আজকে ডেটে সই করাচ্ছ?
25th.
এটা কিভাবে কমিউনিকেট হবে? যা তো অবস্থা তোমার। এখন আর নামামি কি হবে? Anyway, call the matter. কবে টাইপ করতে দিয়ে আর কবে রিটাইপ করে পাঠান আপনারা?
My lord, person to your
I'm for the
lord
state matter.
direction.
But in
my lord,
this matter, I am for the
I already
hearing.
served notice about
For response number 7, 8, 9, 10,
legally
12, 13.
written, sir, my lord, in the righteous building.
I am for the state matter. In this matter.
Notice.
উনি কি বলছেন? You have served notice, sir?
Yes, my lord. Yes, my lord. My
You
lord,
for the state.
I am for the state.
I am
You
for
are
the
for the
private
private
respondent
respondent.
except private respondent number 11 and 15.
my lord. I
11 and
11 and 15. I am appearing on behalf of 7, 8, 9, 10, 12, 13, 15.
you have
14.
filed affidavit of service, sir?
Yes, earlier, my lord.
কোনো ক্যান আছে গো?
Yes, yes, there is a can one.
My lord,
What is can 1?
my
Appropriate
lord,
order.
my lord, can one for appropriate order means, my lord, after filing of this writ application, my lord, some subsequent event, my lord, I enclosing the order in connection with the, my lord, can one. My lord, that's why I further also submitted a
What is your
supplementary.
prayer in the 10 in the main writ petition?
My lord, main writ petition, I filed this writ petition for impletion of the order passed by the subdivisional magistrate, my lord. And the-
10-3 order was passed.
Yes,
10-4 order was passed.
My lord.
yes, appeal was prepared by the client of the landed friend, my lord, and appeal was dismissed.
So you want implementation of 10-3 order.
Yeah, 10-3 order.
Where is that order, sir?
My lord, kindly see the order in the writ petition
Page number 38, sir.
38.
That you want to implement.
Yes, yes.
Yes, sir. What have you got to say? I will hear you.
My lord, we have written to the SP, my lord. We are awaiting for his date. Ask him to provide the police assistance on any date, my lord.
Yes, sir. What have you got to say?
Well, one thing, my lord. The SP has not been made party in the proceeding, my lord.
My lord,
But I am
OC has been made party.
Yes, yes.
Very
OC is there, my lord.
Very
But, my lord, surprisingly, the SP has been made party in the CAN application, but not in the writ application.
No, no, be that as it,
But cannot be changed, but our sir.
be that as it.
Yes, my. But others respondents, I have nothing.
1 minute, my lord. My lord, challenging the order of the appellate authority, my lord, under section 10(4), a writ application was filed in the, my lord, another bench, my lord. My lord, Justice Sinha, my lord, are free to dismiss that. Kindly see this order also.
What is that?
My lord, supplementary affidavit. In the supplementary affidavit or the appropriate order, I include. My lord, kindly see the supplementary affidavit. That order. তোমার ক্লায়েন্ট করেছে, তুমি দাঁড়িয়েছো, তুমি জানো।
I was there, my lord.
This is
That was
Janin.
dismissed.
Where is the 10-4 order, sir?
10(4) order also
And-
the supplementary affidavit.
Page 18 of the Can 1, my lord.
Can one আছে, 1(8). Yes.
The supplementary evidence is there.
Yes, supplementary page 14, my lord, the order of the appellate
find it somewhere?
authority, supplementary evidence.
We have not received the copy of
না,
substance.
সে ঠিক একই জিনিস আছে।
কি ইউজ করেছেন আমরা তো পাইনি, এটা মাই লর্ডকে বললাম, আর কিছুই না।
But only kindly have a look to page 15.
Page 15.
15. But the others, except 7, others they have encroached the land of the PW land, admittedly. But 7, respondent number 7, but he has constructed his shop room on the land of Bimol Podua. He has land 1272. Total 5 decimals. After demarcation, if it is found outside the 5 decimals, I have nothing to say. But it is admittedly that except except respondent number 7, others have encroached.
If you are
The
not encroacher, you need not be worried.
Yes, ma'am. That order may be passed, my lord. The
Nothing.
regarding respondent number 7.
Sorry.
DIB, my lord. There are so many branches, DIB will take care of that, my lord.
Superintendent of Police.
SP Tomlu,
SP
if
Purbo Mendipur.
necessary, SP Purbo Mendipur is necessary. If necessary, he will forward this as a to the DIP.
SP, there are several branches of SP, your lordship knows, my lord. DIB is the concerned branch. We have written what I have handed over to your lordship, my lord. There also is there is indication that SP DIB.
Within bracket DIB.
I have the letter I have handed over.
DIP is the appropriate authority.
SP DIB. SP DIB.
SP DIP করে দাও।
SP the appropriate authority, DIB is the branch, my lord. Director of Intelligence Bureau. Directorate of Intelligence Bureau. SP, there are several branches of SP, my lord.
In district Purbo, how many SPs are there?
No, one SP is there. There are 4 different branches of SP, my lord. DIB is one branch, my lord. Crime is another branch.
The force lies with whom?
The DIB.
Not with the SP.
Well, under SP there are 4 branches. Force is with the DIB.
If I direct the SP,
It will suffice. It will suffice. But
SP will not forward it to SP DIP.
No, no, সেটা না।
but the thing is, well, there was an indication, so I indicated it. my lord.
No, sir, that I have also indicated. I'm just asking for some my academic knowledge.
No, my lord. SP is the ultimate authority. There are 4 branches under the SP.
DIB, my lord, particularly DIB. Within bracket DIB.
Grateful to us.
With the disposal of the instant writ petition,
I appear for the petition. I got the respondent number 8910. My senior was, my lord, yesterday. My senior was mentioned matter.
Lordship, the
Your
matter is,
lordship, my lord, he has not come to court due to personal inconvenience, my lord. I am ready for after vacation.
Lordship, the matter is coming up at my instance. I have already served them and the affidavit of service is also complete. If the same could be taken on record.
West Bengal Highways Act.
Lordship, the private respondents have encroached in front of the vacant land which is lying adjacent to the state highway, Bonga-Boira state highway, which has restricted my ingress and egress towards my suit property. Lordship, in respect of that, I have written several representation to the concerned authorities, including IC Bonga, the assistant engineer PWD, and but even after several representations, Lordship, no steps have been taken by the respondent authorities.
Where is your averment to that effect that our egress and ingress has been stopped?
Lordship, may kindly have regard. Paragraph number 24, Lordship, that your petitioners have been suffering and will suffer irreparable loss and hardship unless the respondents and their agents and subordinates are directed to take appropriate steps against the private respondents by removing their unauthorized construction of shop room from the land of PWD road within the road line in front of LR plot number 315 measuring more or less 12.14 decimal Moza so and such PS such and such district not 24 Parganas to enable the petitioner to reach his plot and also to run his proposed business from the property without any hindrance.
But what is the averment that it is creating an obstruction to the easy access and egress?
Lordship, they are not entitled to make any construction over the vacant plot of land.
But how you are suffering, my sir?
Lordship, Lordship, the suffering is, Lordship, I am entitled to access my plot of land from the said state highway without any hindrance on part of the private respondents. They are not entitled to make any construction over the
How you are going to be affected on account of their alleged
Lordship,
illegal construction?
Lordship, my ingress and egress to my suit
Show me
property.
that line. Show me that line. Any report is there?
Lord, assistant engineer has given a letter to the BLLRO, my lord, for the demarcation of the land of the petitioner and private respondent.
Give
Yes,
that, give
yes.
that. Where you have stated?
Lordship, as I have just paragraph number 24.
Good. Come to paragraph 4. পড়ে আসে না কিছু না। Place.
That the land purchased by the petitioner is bound in one side by Bonga to Boira PWD road. In between the land of the petitioner and the Bonga to Boira road, there is some land of the Public Works Department which was vacant and through which petitioner reached the Bonga to Boira road from his property.
Then next paragraph.
That the petitioner suddenly noticed that the private respondent number 9 is trying to raise shop room in the vacant land of the Public Works Department in front of the property of the petitioner. The petitioner raised objection but was threatened by respondent number 9 and he also assaulted him physically. The petitioner filed a written complaint before Bonga
So
police.
you have to state specifically that in the event the private respondents are successful in raising the construction, your egress and ingress to your property will be obstructed.
Yes, Lordship.
So that has to be stated.
Lordship, that
তুই বলেন লেখে না এসো what is your representation?
Lordship, to assistant engineer at
Where is your representation? Page number?
page number 33 to the assistant engineer PWD.
আসুন Oh, give him a notice. এটা দিয়ে দাও তো হলো।
My lord,
Give it to him, give it to him.
my lord, affidavit of service be kept.
Affidavit of service be taken on record.
I am deeply. এই যে
এখানে দাঁড়ান।
Is there any private respondent?
I'm appearing for the private respondent. Respondent number 9.
West Bengal Highways Act.
Mine.
West Bengal Highways Act.
Yes, your
Kindly see
lordship.
paragraph 19,
Paragraph
19, at page 11.
19, sir.
19.
What they have stated.
He has no personal interest, public interest is involved.
But you kindly see also the paragraph number.
How you are, wait. It is a hard petition.
Your
How
lord-
you are agreed, madam?
Your lordship, if you look into paragraph pleading number 345, you'll see that this plot of land was used for public use as well, and the petitioner used to use it. We have served several representations on the 3rd of July and on the 25th of July, and none of them have been answered. All we are asking is for an inquiry. Last year, an order was passed by Justice Sabyasachi Bhattacharya in pertaining to
Ma'am,
this.
on account of their alleged illegal construction, how your interest is going to be prejudiced? That I intend to know, sir.
Your lordship, there is a road which was used to connect the residents and the local and the highway, and due to the construction, it has obstructed.
Depriving the general public, including the petitioner, of the right to
Yes.
access is a public interest.
And he is a social worker, my lord.
Ashun.
Your
Paragraph.
lordship, all I'm
Paragraph what?
Paragraph 1.
The
Paragraph
writ
one.
petitioner, comma,
May I
the writ petitioner,
interrupt you? Since your lordship, I'm in this also. I'm also in this matter. Since there are your lordship several judgment of the Honorable Supreme Apex Court stating your lordship that the locus standi of the petitioner in respect of the lordship the encroachment by the private respondent, allowed to establish your lordship that the private respondent or the persons had encroached the property. Then your lordship, it is found that the private respondent had encroached the property. Then in that case, the locus standi can be relaxed, your lordship.
Whose
I will, if
property?
your lordship kindly, your lordship, give me 1 day accommodation. Thereafter, your lordship, I can cite the judgment of the your lordship court.
after vacation,
Great, lordship.
as per request made on behalf of the writ petitioner.
No. I'm for the petitioner.
Lord, in this matter, Miss Manali বিশ্বাস has received telephonic instruction last night.
Sorry?
Miss Manali বিশ্বাস is appearing on behalf of this private respondent number 9 to 12.
Huh.
Last night, he has received the telephonic instruction. She has not yet got the Vokalatnama and the petition. Lordship, kindly take it up after vacation.
Lordship, this is a
Take up after vacation, my lord, she will have.
So that you can go with construction.
No, that is true.
Then
I only try to consider my representation, your lordship. Representation at page 52. Page 3.
কি হবে ভিডিও কল করলে অসুবিধা কি আছে একটা
is there any report, sir?
No, my lord, we are ready and willing to, my lord, cooperate. Page number 49, the repetition starts.
Page number 49 or 52?
49 with both are repetitions, my lord. 49
Same
starts.
representation, your lord.
It starts from 49.
The affidavit of services filed today.
Seven.
Give your appearance.
But given.
So I don't know seven. This is the
Affidavit of service get taken on record. এটা কত হবে? এটা item number 7. Who is for the petitioner?
I am for the petitioner.
Mr. Chakraborty for
Private respondents, my lord, some of them.
some of them. Who are your clients, sir?
Respondents 9 to 12 and 14 to 19.
9 to 10 and
9 to 12, my lord.
oh 9 to 12. I'm sorry.
14 to 19.
14 to
19.
19.
My lord, only one thing, my lord.
Give me a second, sir.
Yes. না না আমি অপোজ ইনফরমেশন দিতে পারি
Kindly এটা ওকে ফেরত দিন. Tell me whether the service upon the respondent number 13,
All are served, your lordship, and duly received.
Monirul Islam,
All parties.
Asadul Ansari and Imadul Haq have been served or not?
Lordship, all are served and duly received, your lordship.
Sure.
Sure, Ajit.
You will get the service report. No. Service has not yet been effected.
You say all are delivered.
Delivered.
All are delivered, your lordship.
Delivered to the head office, not to the addressee. Don't call head office.
All address of Domcall, your lordship. All private respondent address of Domcall.
Item delivered to the addressee.
Lordship, delivered and that is shown, your lordship.
এ তো বুঝতেই চায় না.
ডেলিভার টু দ্য
এটা উকিল বাবুকে দেখান. যাও তাও বলে জজ সাহেবকে দিয়ে অর্ডার করাতে পারলেই হল. যাও তাও করে জজ সাহেবকে দিয়ে একটা বোঝাতে পারলেই হল. I folded 3 pages. Take the delivery reports. Delivered to whom?
Domcall issue.
Then next one. Keep the page folded.
Osantupur issue.
Then
The last one.
delivered to
Sumit Patu.
ah,
But your lordship delivered, all are delivered on date was
delivered to the office, not to the address.
not to the address.
Wait for some time. How was that case?
Lordship.
Mr. Chakraborty?
why I was trying to draw the attention, and the only thing is I have verbally been intimated that this writ petition has been filed, but my lord, the wakalatnama is yet to be filed in the department, my lord, so I am not
Ashun. The read
But I beg to appear on behalf of the petitioner.
We have been engaged also from the Elar. They have been from the
Then I will accept the appointment of the owner.
Lord, this dispute regarding Lord, the dispute arises Lord, regarding apportionment of the award that will be declared in connection with the LA case. Lord, started under the Lord National Highway Authority Act. Lord, the cracks of the Lord, the petitioner.
Give me a second, Mr. Ghosh. No private respondent.
Yes,
Yes.
SART on last occasion, my lord recorded, service has been effected upon them. And my lord directed me to.
That has been acquired by the National Highway Authority,
Yes.
not by the state government. National
Sorry?
land has been acquired on behalf of the National Highway Authority Act 1956. If they are agreed by the award or apportionment,
Just a minute, sir. Yes, sir. What is your contention?
Lord, my contention is that, Lord, the private respondents, the private respondent's name has been recorded wrongly in the LR record of rights.
Yes.
Lord, they divested themselves from the property long back by execution of the registered deed in favor of the third party. Now,
Yes.
Lord, the LA notice in connection with the LA case has been published and the notice has been given in favor of the private respondent. Now, it is the intention of the Lord, the collector to distribute the compensation award amongst the persons whose name appears in the LR record of right. To that effect, Lord, I filed a representation before the concerned authority not to delete, not to give the any compensation award in favor of the private respondents. That representation still kept pending. Lord, either kindly direct either them to dispose of my representation or refer the matter in view of the section 3H4 before the principal court of law, principal civil court of law.
Now, how that can be done by the writ court? Notice issued in 2013 and you are 2025. There is no explanation. 2013 land was acquired. And hearing took place on 19 December 2013, page 46.
Wait, sir, wait. Which are the relevant pages?
But page 46.
Just a minute, sir.
Lord, serial number 5. He is one of the private respondents. Now, Lord, kindly.
Page number, sir?
46.
Page number 46 is what is that?
Lord, the notice in connection with him, Lord, the hearing of LA case. My Lord will find from the top serial number 5, that is the one of private respondent, Zakir Ali Mondol. Now, Lord, kindly come to page.
Who is Zakir Ali Mondol?
One of the private respondent, Lord.
Yes.
Now, Lord, kindly come to page 50.
Zakir Ali Mondol is the private respondent.
My Lord.
Respondent number
10.
10.
Yes.
Yes.
Now, Lord, kindly come to page 50. 50.
Page 50.
My Lord.
Yes, sir.
Lord, his name is wrongly appearing in the LR record of right. Zakir Ali Mondol at top, Lord. Right hand side.
Zakir Ali Mondol. Why have not mutated?
I did not. Lord, the private respondent wrongfully they mutated their name.
Oh, I see.
Despite the relinquishment of their right in favor of the third party, Lord.
But he shall have
Where is your
been
representation?
Lord, my representation is, Lord, at page 60.
Before the competent authority?
Before the competent authority.
Kala.
My Lord?
Kala.
No, Lord, he shall be the special land acquisition collector.
But until unless record is corrected under section 50 small of the West Bengal Land Forms Act.
No, sir. If we read section 3H within bracket 3, where several persons claim to be interested in the amount deposited under subsection 1, the competent authority shall determine the persons who in its opinion are entitled to receive the amount payable to each of them.
No, that incident took place 2013. We are in 2025. Can you see page 46? 19 December 2013, or we are in 2025.
Page number?
Page 46 and 47.
But award has not been
Then he could have come immediately 2013. We are in 2025. And records to be correct.
Award has been distributed.
no, Lord. They are
You determine.
going to
You have not made the apportionment.
no, Lord. That has not been.
Apportionment made on the basis of the record of rights available to the government. But a notice was issued in 2013.
So far,
He could have approached the server code 2013 itself. This is a wrong recording. Award will be passed in favor of the persons whose name has already been recorded in the record of rights.
correction of
According to him,
appropriate.
it has not been disbursed.
No, I'm not saying that. If land has been acquired in 2013, notice was given. If he was agreed by the notice, he could not have filed an application under section 50
You have been served with the notice.
National High Authority.
The notice has
Yes.
been page 56 that was given to me also.
And
Page
record
40.
correction has
For the
to be made.
correction of record of rights, tribunal, my lord,
Tribunal is the
tribunal is
jurisdiction.
Why you have not approached the earlier?
Lord, they have not, Lord, I am giving the reply to my learned senior friend. Lord, unless until, Lord, the award has been awarded, money is distributed in favor of the interested party, Lord, cause of action, Lord, arises. Lord, cause of action runs, Lord. They have not, Lord, distributed, Lord, the compensation award in amongst the person who are interested under the act. Lord, only they have published the notice and they are going to, Lord, distribute the compensation award amongst the person interested. And Lord, so far as the correction is concerned, Lord, I filed an appropriate application before the BLR. Lord, this is the feed case where the Lord 3H4 shall be exercised. Kindly, Lord, my learned senior friends, client can exercise this power and refer this matter to the principal civil court for determination of the who is the person who shall get the Lord, the
No, that can be done when there is a dispute with regard to the apportionment.
Apportionment.
that is the case, Lord. I say the private respondent will not get. We alone will get. Because private respondent, where my co-owner, they divested themselves from the property by executing the registered deed of sale long back. Lord, what happened? The property belongs to our forefather. The forefather has the 3 sons. We belongs to 1 son. Private respondent belongs to Lord, the another son.
So
and
dispute is with regard to the apportionment or not?
my Lord.
What is your contention? In the writ petition, what is your government to that effect?
Can you see? Prayer B. Prayer B.
Lord, the page 3, last 3 line.
Page?
Page 7, paragraph 3, last 3 line. The dispute arises in the present land acquisition proceeding as regards the disbursement of the compensation in favor of the private respondents who are not at all the owner of the land acquired and or in possession of the said property. The private respondent herein by taking aid of the wrong recording in their name in the record of rights take their claim over the
Then correction of-
compensation awarded and proposed to be disbursed to present case. And
So for the correction of record of right is concerned, my lord, they should approach with the tribunal.
then restrain them, Lord, not to disburse the compensation in favor of anyone.
Which tribunal?
For the
Land
land record
tenancy
service, for correction of record of rights.
First,
Sir, peruse the section 3H of the National Highways Act.
if there is a dispute between the
Ashu.
এই রিপোর্ট দিয়েছি এক্সেপশন দেবে নাকি ওকে এক্সেপশন দেবে
রিপোর্টটা তো দেখিনি আমি
Yes.
My lord, this is the matter which was earlier heard. In continuance to that, this writ petition has been filed. Your lordship passed an order on 26
Provide the
2025.
report, Mr. Dhar.
Report has been yes, my lord.
বুঝেন কবিটা
My lord, kindly see the order at page 76, my lord.
Give me a copy.
Copy
Copy
has
receipt,
been-
my lord. Copy receipt.
Receipt.
Yes, my lord. Copy receipt.
Page number.
Page number 76 of your lordship's order, my lord. In the writ petition, my lord. Page number 76. This matter was already decided by your lordship.
Yes.
Place it, my lord. My lord. Page 76, the order. The supplementary affidavit is filed on behalf of the writ petitioner is taken on record. By filing the instant writ petition, the writ petitioner has prayed for issuance of appropriate writ/writs against the respondent authorities for allotting an alternative sand block having
Either as it may.
My-
Ultimately,
ultimately, my lord,
liberty was granted to approach here for grant of environmental clearance certificate upon compliance of all
all
formalities.
formalities, my lord. So, my lord, we submitted two representation before the additional district magistrate.
Just a minute, sir. Then what happened?
My lord, in compliance of your lordship's order, my lord, a liberty was given to approach before the SIA upon compliance of all formalities, my lord. Hence, we submitted two representation. One seeking request for permission to modify the geo coordinates of the sand block to nearest potential zone as per approved district survey report, which is at page 79. And page 81, we requested to review the mining plan in respect of such and such sand block, my lord, so that we can approach before the SIA after this either of
Just a
the,
minute, sir. Just a minute.
my lord.
So it is for change of modify the geo coordinate
Yes, my lord.
in the self-same plot.
In the self-same plot.
And what is the 70 and what is that next?
Next is page number 81, my lord. We requested to review the mining plan in respect of the self-same sand block, my lord, which has been already approved by the authority in the DSR. My lord, we have prayed for consideration of these two either of the representation, my lord, so that we can approach before the SIA seeking environment clearance.
sir.
Review the sand mining plan.
My lord,
Those are the formalities for approaching SIA.
my lord, SIA, if my lord, the my plot does not fall within the potential zone, my lord. Hence, if they does not modify, review or modify my geo coordinates, my lord, I can't approach SIA because SIA can grant
And
environment.
review the, what is the review of a mining plan?
My lord, my mining plan was approved earlier by the chief mining officer, which is at page number. Yes, my lord. At page number 23. At page number 23, my lord.
No, on the last occasion, you did not get environmental clearance since your approved mining plan does not fall within the potential zone for which you have prayed for review.
Yes, my lord.
So what happened?
Then, my lord, we preferred this writ application, and your lordship passed an order on.
Yes, I understand. Now you have prayed for modification of the geo coordinate with a further and request for review of the mining plan.
Before
So what they have
district
done?
authorities, they did not take any steps, my lord.
Hey,
My lord, with my learned senior's permission, my lord, may
uh,
I mean, your lordships. My lord, your lordship kindly come to page number 76.
page number
78 first. Para number 7. On careful consideration of the entire materials as placed before this court, while disposing of the instant writ petition, grants liberty to the writ petitioner to approach ACIA, State Environment Impact Assessment Authority. Directed the response number 5. My lord, what he has made, he made an application before the additional district magistrate, district land and land reform officer, Purbo Bardhaman, post Purbo Bardhaman, district Purbo Bardhaman. Both the application has been approved before the district magistrate. My lord, SIA is different body and different entity. So lordship kindly come to my lord. The response number 5, the address is different, my lord. And also your lordship directed the said person to be approached, my lord. Response number 5. Instead of
no,
that,
upon compliance of all formalities.
Formalities. First of all, comprehension. First of all, he should. My lord, formality. My lord, first of all, he should make an.
No, sir. Try to understand. SIA rejected their application for environmental clearance on account of first, the writ petitioner did not have any valid accreditation certificate. Second, the plot area of the proposed as per approved plan does not fall within the potential zone, and the writ petitioner has not uploaded the original LOI. Now the writ petitioner has approached you for modify the geo coordinate and the review of the mining plan, as otherwise his prayer will again be rejected.
Or SIA for grant of environmental clearance certificate upon compliance of all formalities, and in the event sir approach is made.
So these are the formalities.
Formalities. My lord, your lordship kindly, I have submitted the report before lordship. Because my lord, there are several, my lord, clauses are there. Several criteria are there. First of all, the land at the time of execution of the lease, he was given the liberty to, my lord, visit to the place where the lease used to be granted to him. He went there and also, my lord, accepted all the terms and conditions. Thereafter, due to the change of the course of the river, the said position has been, my lord, different way, my lord, has been changed. And also,
what is the difficulty in changing,
my lord,
modify the geo coordinate?
Because of the quality of the sand, quantity of the sand, after changing of the course of the river, my lord, goes less.
Then modify the geo coordinate. What is the difficulty, sir?
After my lord DSR, first of all, the authority was with the DSR. Thereafter, it has come to the authority of the State Impact Environment Authority. My lord, after considering all aspects to the said place by the district survey committee or the state survey committee, consists of different bodies, engineers, surveyors, in something, the area falls under the non-potential zone. That's why, my lord, no way, my lord, the land cannot be granted.
Then refund the money.
Only that can be.
Yes, then refund the money with interest.
Yeah, that can be. That can be. That can be, my lord, this is the instruction.
This is unfortunate.
With interest, already a decision হয়ে গেছে.
My lord, your lordship already has decided the matter.
Because if the area is not within potential zone, because the change of geo coordinates, that will amounts to grant of a new area, which is not permissible in terms of 2016 rule.
That has been indicated in your report.
State has submitted the report.
First, my lord, e-auction should be taken. Otherwise, it cannot be granted.
Without auction,
it cannot be granted.
My lord, the matter has already been decided by your lordship, and the
And in
report is
what-
beyond the scope of your lordship's order, my lord. All res judicata points has been taken in the report.
What is the full form of DSR?
District survey report.
Yes, sir. Then, my lord, during the pendency of the writ application, my lord, a notice was issued by the earlier writ petition, my lord, and a notice was issued by the district authority at page 73, my lord. And
Wait for a second.
yes, ma'am.
It is crystal clear.
Let me come back at 2 p.m.
Okay.
My lord, may I be permitted to mention matter?
This is not the mentioning hour.
That due to some urgency.
Whatever may be the urgency, I'm sorry.
Deeply obliged, my lord.
You have placed a request for modify the geo coordinate of the sand block to the nearest potential zone. That tantamount to change of
Yes,
plot.
that's why I said that it is not permissible.
Not possible.
In terms of Rule
No, I have
38.
gone through this. So how it is possible? You take refund. Hey, Ashwin.
Every year, my lord, one more submission, last submission. Every year, my lord, the district survey report is being published, my lord. Every year, this is the policy of the government, district authorities, they publish district survey reports. Then, my lord, at page 73, kindly see, my lord, page 73, during the pendency of the earlier writ petition, a notice was issued by the government additional district magistrate wherein regarding uploading of DSR, my lord, kindly see the below portion. All interested persons are requested to submit claims and objection for finalization of DSR within 30 days at the MM section of the office of the ADM and DL LRO, Purva Bardhaman at Rajawad. In compliance to that, my lord, at page 74, we requested to include my sandblock in the potential zone under the amendment 2023 DSR, my lord. But they did not do that also, my lord. And every year, my
Be that as it may, but as on this day, the change of the potential zone from one block to another block is not possible. Take down here, হবে না.
Then, my lord, kindly
No, sir, sorry.
Kindly, my lord, my lord,
This
my
subject matter
in my lord, of the minor mineral concession rules 2016, my lord. Part 1. A prospecting scheme prepared and submitted under Rule 8 may be modified at any time on geological consideration by the holder of a prospecting license cum mining lease during continuance of the prospecting period. Any modification carried out under sub-rule 1 shall be intimated to the state government by the holder of a prospecting license cum mining lease within a period of 15 days. my lord. Can it be considered well?
Let's do one thing. Let's see, this is said during the continuation. Here, let's see, lease has not been executed.
বলুন কি হয়েছে 18. Is there any private respondent?
Yes, my private respondent is there, my lord. Respondent number 4.
Who is for the private respondent?
Mr. Obligate Mitra appeared on last occasion, my lord. These are matters.
Mr. Obrojit Mittal, senior advocate, appeared.
Yes, yeah.
And they had filed one application. Your lordship had directed the private respondent to serve upon the parties and come back.
Who has filed the can?
My lord,
Can they have filed, my lord? They want to, my lord, this is a private. They want to, my lord, frame it out.
You are led by Mr. Mitro.
no, my lord. I appear for respondent number 2. I'm led by Mr. Bishuru Bhattacharya.
This one or two?
Webel.
The last occasion you didn't appear.
Yes, my lord.
নাম পাচ্ছি না তো।
Last occasion, yes, my lord, we were there. I appear for respondent 2 and 3, my lord.
You are for state. And who is for Webel?
My lord, I appear for Webel, led by Mr. Bishuru Bhattacharya.
And who is for 4?
The 4 Mr. Obligate Mitra was appearing.
Can application.
Would it be possible to intimate Mr. Mitro or any of his junior that will be taken up at 3 p.m.? Because there is a direction
It's for 2 p.m.
there with the mark 2 p.m. But it was not indicated in the list.
But it was the direction when it was given in the open court also.
That's true.
3 p.m. 2:40. 2:45 I have a fixed matter before Bhattacharya.
I appear for West Bengal Electronics Development
Who is
Corporation.
for the respondent of 4? Very good. Who has filed this can?
We have filed a can, my lord, challenging the maintainability of the writ petition.
Right.
Give me a second.
The face of is in abuse of process.
Yes.
Application for dismissal.
Take some breath. Which letter is under challenge? Which
Lord,
member?
Lordship will kindly seize, my lord. Lordship, my lord, I have annexed it at page. Yes. Page 50. Sorry, page 56.
You need to take water.
No, my lord.
I can give you.
No.
Then take some breath.
I'm led by Mr. Mitro.
The second paragraph is little bit peculiar, no?
Yes. My lord, that is my case before your lordship. My lord, today, my lord, good, bad, my lord, I had taken a, my lord, sublease from Webel. And Webel is the, my lord, lessee of Respondent number one, the state.
You are the writ petitioner is the Ishani.
Ishani, yes. It's Ishani. I am for the Ishani, ma'am.
They describe themselves as an WBEIDC.
Yes.
And why you are describing them as Webel?
Well, there's a short form I'm using.
Huh?
No, Webel not Mala. Their name I have written in the cost item. It's written, yes. Well, West Bengal Electronics Industry Development Corporation Limited. Yes.
But they use the term WBE. You are WBEIDC.
Webel.
Oh, Webel.
Webel. Later is also Mala Webel.
Huh.
I am the sublessee.
Now, this has reference to your letter regarding lease deed. That such and such executed between the Webel. Sometimes they write Webel and sometimes they write WBIDC. Same.
Same. Yes.
And measures.
Same. It's same.
Anyway, place your case.
Now, my lord, this letter.
What is your can is yours.
Dismissal application. Really, all three.
I'll look to this. I just want to see what is the dismiss, stay, be directed to grant permission to applicant. Very well. Let me hear him first.
Well, my case is that, my lord, as per the lease deed which was executed in 1994, that is at page, my lord, 21 of your lordship's writ petition. Lordship, this lease was executed only to develop the electronic industry. It's for setting up a factory. Well, at page 22, well, if your lordship sees, if I can read for your lordship.
Page number 21 is the lease between whom and whom?
Between, my lord, state. This is fellow Webel and he. Yes, Ishan. Lordship will kindly see the cost title, my lord. The Bengal, my lord, West Bengal develop industry and versus. Yes, Ishan. Ishan is there. My name is there. Yes. Now, lordship will kindly see, my lord, page 22.
So why they are referring as you are as a sublessee?
Yes, original. This is the UD has given lease to Webel. Now Webel has sublet me. So for that, I am the sublessee.
Very good. Then
now, my lord, lordship will kindly seize, my lord.
Main object of the lease in favor of the sublessor.
If your lordship kindly sees 21 second paragraph. Just I'll read for your lordship. Your lordship allows.
Who is the sublessor then?
I am the sublessor is Mr. Bhattacharya's client.
Well,
yes.
Very good.
Now lordship will kindly see, before your lordship proceeds, I'll just read a paragraph of page 21, second paragraph. Whereas
before the matter is proceeded, it is my duty, we have instructions to take the point of demurrer. The writ petition essentially arises out of contractual dispute between my learned senior friend's client and my learned friend's client. Roping in Webel in the process, is complete, because the pleadings in the writ petition is very significant. And the writ petition is
let me hear, sir.
Only one thing. writ petitioner should disclose before your lordship's court, certain essential facts, which appears to have transpired inter se them, these two parties.
This was already discussed.
If that be the so, the writ decision cannot be invoked.
There are, kindly visualize. Section 9 proceeding.
Mr. Bhattacharya, please allow me to make submission.
Right.
Otherwise, it will be absolutely haphazard way.
What
Make
has
your
happened?
submission.
My lordship will kindly see page 21, first paragraph, second paragraph. Whereas by a deed of lease, herein referred to as the original lease, dated 19 January 1987, the governor of state of West Bengal, therein referred to as the lessor, has granted a lease for a 99 years of so and so many areas, acres, more or less of plot of land in EP and GP in sector 5 of Bidhannagar in district 24 Parganas north within the police station Bidhannagar, registration office so and bounded by north Mala so and undeveloped land on west by type 3 road to the sublessor on terms and conditions contained therein and detailed in the first schedule herein written, and the said original lease was registered at the Office of Register Assurance, Calcutta, India, 1987. And whereas the sublessor obtained a lease of the said land with the object of developing the said demised land for setting up electronic industry thereof, and has undertaken a project in terms of whereof the sublessor has divided the said land into diverse plots and has allotted some of the plots for industrial purposes and on terms and content therein. In the letter of allotment of industrial plot in Salt Lake Electronics Complex, fully detailed in the second schedule herein under written, and the said terms and conditions of the letter of allotment shall be adhered to by allotee. And whereas the main object of the said lease is in favor of the sublessor is to develop the leasehold area as an industrial complex for electronic industry only. And whereas under the original lease, the sublessor has been authorized to subdivide and sublet the demised land for the purpose of setting up different units of electronics industry only, and it has been enjoined upon sublessor not to allow the said demised land or any structure constructed thereon to be used for any purpose other than for setting up of electronic industry. And the lease is very clear. Today, even if my lord Webel comes and say this is a private thing, my lord, may I clarify the situation? My lord, the original lease granted by the state of West Bengal is only for setting up of electronic industry. My lordship knows much better than us, my lord, in respect to the Town and Country Planning Act. When suppose an area has been given for specific, for notified, for setting up of an industry, you cannot change that. Now, good, bad, indifferent, my lord, one of the shareholders have entered into an agreement in a memorandum of understanding with respondent number 4 in 2016. Now, what has happened, my lord? Now, what has happened? That MOUs is there, no steps has been taken till date. They have filed a section 9, and after that, arbitration is pending. We have taken a cardinal point before this court, and we have made a representation before the state of West Bengal UD department and also the Webel.
Who are you?
Well, I am the Ishani, the sublessee of Webel. Well, I have taken a specific point. See, good, bad, indifferent, our agreement MOU was there, but that was only for in respect to residential complex development. So, as per the original lease and as per the terms of the lease, that is a violation, Malad. I want to rectify or kindly take steps so that rectification can be done, or I am ready to adhere in respect to construction of electronic industry is concerned.
What sort of rectification you want?
What I am seeking before your lordship is that, my lord, if today,
why you approached the Webel?
It was my duty to point out that, see, today, if today, give you an example, if today, ultimately, my lord, this is set up for a commercial purpose of in respect to residential purpose is concerned, then the entire lease deed is frustrated. And the main loser will be Ishani Electronics, the petitioner before your lordship, because knowing fully that this land is only for setting up of an electronic industry, my lord, even if I have done a wrong, but as it is not executed in a final way, so I have just made a representation before the UD and before the Webel. Now Webel comes with a letter that is astonishing for me, and that is challenging before your lordship, page 56. Well, what does it say? And he is going beyond his terms, and he is dictating that you go and Immediately, my lord, complete the necessary formalities for entering into the developers agreement. Lordship will kindly see what the OABL is doing. My lord, this is a reference to your letter. Lordship will kindly, your Lordship has read it, my lord. I'll just point it out.
Retrospectively.
Yes. So, my lord, today, my lord, OABL being the lessee.
What is the sublease agreement between you and the?
That is, I've read before your Lordship, page 21.
21 is the original one?
No, original lease
Oh,
deed, but my entire details have been given in the first 3 paragraphs. On the basis of this, he is giving me lease. It is not
Just a
his
minute.
choice.
Where is this original letter? No, you have not placed that portion.
My lord.
Come to the last part, one paragraph of page number 22.
Yes, my lord.
That is required to be placed.
Yes, my lord. I was placing my
Yes.
Lordship will kindly, my lord, from the 3rd paragraph, I will place, my lord.
Last but one paragraph.
Oh,
That is the purpose of lease has been executed. Mention.
Yes, and whereas the sublessee has applied to the sublessor for the sublease for term 90 years of one of the plots of the said industrial estate fully described in the 3rd schedule herein under for exclusive purpose of setting up an electronic industry and for no other purposes.
So according to you, the original lessor being the government of West Bengal granted a lease to the OABL for setting electronic purpose.
Electronic industry.
And in the same tune, the sublessor has granted a lease to the sublessee being your client only for setting up an electronic
industry and nothing else.
Place this next paragraph.
Yes. And whereas by the sublessee, and whereas the sublessee has given written
Sublessee means your
yes,
client.
I has given written undertaking to the sublessor that the said plot described in the 3rd schedule hereof will not be used by the sublessee for residential purposes or any commercial establishments or any factory or workshops or for any purpose other than manufacturing of electronic items. Even I cannot establish a factory for.
So basically these are the purpose of the lease.
Purpose of the lease.
Then what representation you have submitted?
Now, Lordship will kindly seize Mallard to the UD I have given Mallard. First, I'll read it Mallard because UD is the main party Mallard because he is the original Mallard party as he is having the land.
UD means?
Urban Development and Municipal Affairs. Yes.
UDMA.
Yes. Lordship will kindly seize Mallard page 50. Lordship will kindly takes Mallard. Page 51 Mallard. Page 51. It is stated that very incorporation of the said
page number 50 is the starting page.
Yes, very starting last portion I am reading what I have stated.
Yes, sir.
Yes, it is stated that very incorporation of the said MOU, which was unknown to us, is in violation of the said restrictive clauses as enumerated in the lease deed dated 11th May 1994, and as such, the same having been derived in our knowledge, the said MOU cannot be acted upon.
Very incorporation of the said MOU means?
MOU with the memorandum of understanding that was between me and respondent number 4 for development of commercial buildings in respect to residential buildings, not for electronic industry.
But you said that you have not understood. You have not entered into the MOU.
No. What I have stated, my lord.
One of your shareholder entered.
No, my lord. This is a company, my lord. All the shareholders are there, my lord. There was a whatever maybe, my lord, there was a misconception or anything has happened, my lord. Our MOU has been entered. I cannot dispute that. Our MOU is there. Now, my lord, the problem is that when we are concerned that this MOU cannot be enforced ultimately because the main the position of the lease is that it has to be established for an electronic industry only. Even if they get a decree in the arbitration, they can get an award from the arbitral tribunal, then also it cannot be enforced. It is against the government law, it is against the statute, and it's against the clauses. It cannot be executed. If today I enter into an agreement to sell something government property, that cannot be executed.
So what is your prayer before the UDMA?
Yes, Lordship will kindly see last portion, I was reading that,
Well, it is stated that we, the shareholders of the said company, receive knowledge about the said MOU only after receiving the notice of the appointment of an arbitrator pursuant to the direction of the Honorable High Court in an application section 11 of the Arbitration and Conciliation Act 1996. It is only after receiving such notice that we, the understand, realize the mistake committed by the said company in executing the said MOU, which violates the terms and conditions of the said agreement. It is furthermore stated that we, the shareholders, upon conduct of a meeting of the Board of Directors, have come to the conclusion that the pertinent steps ought to be taken to prevent such violation of the express terms and conditions of the said lease deed dated 11th May 1994, which was erroneously and mistakenly entered into by the said. You are hereby requested to kindly take necessary steps to forthwith take action to prevent such misuse and provide us with an opportunity to rectify the situation at hand. Well, I have just made a prayer. Just see if something wrong has been done, but that cannot be executed as the original lease deed doesn't satisfies the clauses that if today also, if my learned senior friend gets an award in his favor only, can this award be executed? He can at best claim damages. Two things are separate, my lord. Agreement cannot be enforced, but he can always claim damages. For that, arbitration is pending. I am also defending over there. I cannot deny that. His right to get damages cannot be with. He can always get that. But the enforcement of an agreement, my lord, is a determinable in nature. My lordship knows much better than us, my lord. If the agreement is determinable in nature, it cannot be enforced. That is my case. And now, my most interesting thing is that my waybill has come out that you do the. You immediately go for the developers agreement. How can
that
you do that?
Retrospectively?
Yes. How can you do that, my lord? I am before your lordship.
Then what is your prayer then?
Lordship will kindly see my prayer. This is a public land, my lord. Page 16, my lord. Lordship will kindly see. It's a prayer. Read in the nature of pandamus or like nature of orders or orders be issued commanding the respondent authorities and or their main agents and subordinates, more specifically the respondent number 1. I am against respondent number 1. I am seeking the prayer. Fourth, we declare that the respondent number 2 cannot issue purported letter dated 24th April 2025 for immediate compliance toward the execution of the developers agreement retrospectively. Second prayer is lordship will kindly cease, my lord. Commanding the respondents, authorities and main agents, subordinate, more specifically the respondent number 1, to forthwith consider and declare whether the memorandum understanding dated as entered into by petitioner and the private respondent are valid in the eyes of law or not. C and D is very important, my lord. Thereby directing the respondent number 1 to submit a report, thereby clarifying whether the memorandum of understanding has entered into between the petitioner and the private respondent number 4 is valid in the eyes of law in the light of restrictive clause iterated in list dated 11th May 1994, and order thereby directing the respondent number 2 to submit a report, thereby clarifying whether the respondent number 2 is authorized to pay for the notice dated 24th April 2025. I have taken a cardinal and basic principle, whether they have right. And this is a public land, even I have done something wrong, I have surrendered myself.
What is your stand?
The government has, the granted leave in favor of the Wable the year 1987.
For what purpose?
For setting up the electronics company. Thereafter, they are in possession. They established, in favor of the Ishani. Now, Ishani, entered into an agreement with the Creed. And then a letter has been issued by the page 56, your lordship kindly come to page.
Yes.
Which is under challenge.
Yes.
And the proceeding has been initiated in the Arbitration and Conciliation Act.
Forget about that. What is your stand? I intend to know.
I have to take instruction, my lord.
No, if a public land, Mr. Bandhavadai, listen to me, a public land is entrusted to a lessee, is a lessee for a particular purpose. And if it is found that the lessee is using or permitting the others to use the land for the purpose for which it was not let out, can a welfare state allow the sub-lessee to do that?
Well, they have not annexed the original lease deed herein.
Original lease I don't have.
Not in a position to, my lord, what are the conditions
Very
and
good.
terms and
Mr.
conditions.
Bandhavadai, Mr. Bhattacharya, what is your stand?
One submission, my lord, whether this writ petition is maintainable before this honorable court. It's a contract. Lease agreement is contract. If any violation is there, whether the writ petition is maintainable. There is other forum before they have to approach before the other forum. When there is any breach of contract, lease is a contract, your lordship knows very well, Milord. This is not the forum to challenge the lease.
But if it is found that the state has failed to discharge its sovereign function,
What was the
if the court finds that the state has failed to discharge its sovereign function, even then the credit is not maintainable.
Let them, my lord, file the original lease deed, or I shall take instruction, my lord, from
Very
my
good.
authority.
What is your stand, Mr. Bhattacharya? Please take your seat, sir.
Kindly takes the writ petition. Now, my first submission to your lordship is, whatever my sublessee, I being the sublessor, whatever the sublessee has been doing, or whatever it has done, is without any permission from us.
Without
any permission from us. They are obliged to take permission in terms of the 1994 Milord agreement between Milord.
That you have indicated in the first paragraph of your letter under deference. Letter under challenge.
Permission. Now, Milord, please come. Attention of your lordship was just now invited to page 55 first. Very interesting set of facts. Just to, Milord, if I may say with Milord trepidation, Milord, to hoodwink this court. It is stated that we, the shareholders of the company, received knowledge about MOU only after receiving the notice of appointment. Milord, is it believable? Kindly seize his averment in paragraph 3 of the writ petition. He, Ishani, enters into a MOU and feigns ignorance about the MOU.
Mr. Bhattacharya, I am exactly on that. I am asking that question. But then what prompted you to
I am coming to my prompting. I'm coming to it. Milord, a writ petition, essentially, it's an equitable jurisdiction, apart from anything else. One who has a legal right and a corresponding legal obligation on the part of the respondents, the breach of which is alleged, then only a writ petition is perhaps maintainable. Here, whose breach is being alleged? The writ petitioner's averment in the writ petition. Please see the writ petition.
Yes.
Now, please see paragraph 2. The respondent number 2 is the original lessee. That is my client.
Yes.
In respect of aforesaid premises being plot number such and such, kindly ignores it. By virtue of lease deed dated 19/1/87. Executed in between the government and respondent number 2 for a period of 999. It is imperative to mention here that the respondent number 2 as sublessor had sublet the premises for the remaining period of the lease in favor of the petitioner. Being the sublessee, wide lease deed dated 11/5/94 for the very specific purpose of setting up of electronics industry as abbreviated in the terms and conditions therein and for the period of 90 years from the date of execution. Pausing here. So he knows on oath, he says that he has understood what the sublease agreement was all about. On oath, he says, being the sublessee, for the very specific purpose. So he knows what the purpose was. Then, a bare perusal of the various clauses of 11/5/94, that is, Milord, me and the government. 11/5/94 is government, Webel and Ishani, writ petitioner, will render it beyond doubt that such lease deed was granted in favor of the petitioner in a very restrictive capacity, that is solely for development
of the land as industrial complex for electronics industry only, thereby restricting the petitioner from using the area for any other purpose that was iterated in the lease deed dated 11. Perusal of the recital of the said lease deed along with the clauses will render such fact evident. It is imperative to mention here that contravention of the terms of usage of the said premises has its own consequences as enumerated in the said lease deed, the very clause of which was overlooked, the same being an inadvertent mistake on the part of the petitioner. It is further imperative here to mention that even the private respondents, despite having knowledge, I put this question to myself, the writ petition is couched in such a language as if to suggest that some other person is to be blamed, and they are absolutely beyond any cavil of doubt, they are saints.
Mr. Bhattacharya,
they have entered into transactions.
Mr. Bhattacharya, I'm very sorry to pause you. It may be, or it is very maybe, or it is very sure that the writ petitioner wants to avoid the contract as has been entered into by and between him
what
and
he
the
wants to. Yeah,
respondent number 4. Respondent number 4, maybe.
My lord.
I'm giving a hypothetical situation because from the submission. But what I'm on, that you being the Webel is a fully government-owned company, is an authority under Article 12 of the Constitution of India. How can you permit the writ petitioner or any other person to utilize the leasehold land which has been given by you, given to you by the government for a specific purpose, for allowing for using the same, or for allowing the use of the same for a different purpose?
We are not giving them.
Then
we have not accorded any
why?
permission.
What is the meaning
Please
of
come.
paragraph?
Please come.
Second paragraph.
Please come. Please come.
I understand your content.
Please come to our agreement. Page 21.
No, Mr. Bhattacharya, please prior to that I will come. Please read once page number 56, second paragraph. Then you justify your action.
Yes, the necessary formalities implying, my lord, whatever is contained in 1994.
Kindly read, sir.
For entering into development agreement retrospectively. Development is intercept development as, my lord, contemplated in the 1994 and nothing beyond that.
Are you sure that development agreement for setting up an electronic complex?
Yes, 100%. That is our agreement. That is our agreement.
Between the writ petitioner and the private respondent.
We are not looking into that agreement. We don't even recognize
that.
We are not looking into any agreement.
Sir, then the court will issue an order.
Please understand. Please see.
Sir, why you are taking the side of the...
I am not taking any sides.
Why you are taking the side of the respondent number 6?
I am not taking any sides.
You being a fully government company, Mr. Bhattacharya, is duty bound to act in a manner by which you are supposed to do. You are an authority under Article 12. I want to know when you have issued the letter, are you aware the nature of the agreement between the petitioner and the respondent number 6?
No.
Then you are requested to complete the letter for entering into the development and explain retrospectively.
Please.
Yes, sir. What is this?
Sir, it has come to the notice, my lord. This is by the UD and MA. It has come to the notice of the government in the urban development that the number of lessees of non-residential land of Salt Lake entered into development agreement with developers by transferring proportionate shares of leasehold land, built up spaces of the building with proportionate share of land with or without prior permission. The matter of realization of transfer fees for the cases where lessees of non-residential land at Salt Lake entered into development agreement with developers with commitment from the lessee for transfer of leasehold land for the land build up space with proportionate share of leasehold right of land to the developer with or without prior permission of the government was under active consideration. Now, after consideration, the government in the UT and MA department has decided that the following permission fees will be charged for such cases in case of non-residential land at the Salt Lake. This prompted us Lord, when, Lord, please see their letter of 16th April 2025. That is at page 54.
Now, notification does not say about the change of the mode of user of the PWs. It is with regard to the transfer fees.
Milord, it says following permission fees will be charged for such cases. Milord, what are the cases? Milord, please fall back to paragraph 1. Non-residential land of Salt Lake. Milord, the land in question. Milord, first of all, Milord, let us be very correct on this aspect. I am not appearing for the respondent taking any particular side.
That exactly I want.
Webel is not taking any side. Webel is not bothered. Absolutely not bothered. Webel has entered into some arrangement with the writ petitioner. That is an admitted factual position.
What arrangement, sir?
Yes. Please fall back to the arrangement, page 21.
Yes.
Yes.
It is not at page number 21, page number 22.
22.
But one paragraph.
Milord, please see, I am reading, Milord, since it is not legible in the writ petition. Milord,
for the exclusive purpose of setting
Milord,
up.
Please come. At least, Milord,
entry.
Mr.
And for no other purpose.
Mr. Chattopadhyay will pardon me for, Milord, at least saying this, because he has been making this murmuring that, Milord, I am taking sides. But this page is at least not legible in my writ petition.
Give him a legible copy.
Page 22.
Give him your brief.
Whatever. This is the.
Well, I have given the legitimate copy. If my learned friend wants one, I can always give.
কি বুঝতে পারলাম
Anyway, be that as it may.
Very well.
Now, copy now.
22 টা খোল। তোর 22 আর আমার 22 এক নয় কেন? এটা কালো হয়ে গেছে যখন জেরক্স করা হয়েছে তখন এটা এরকম বেরিয়েছে। সার্থকে তুই আপলোড করে দিস কেন এরকম?
আমি কেন আপলোড করব? মেশিনের জন্য।
Very well. আমি রেগে যাব।
Yes, Mr. Bhattacharya.
Strange. Now please come to internal page 2.
Yes.
Now please see, whereas the sublessee at the bottom, I am reading page 22 of the writ petition. Whereas the sublessee has given written undertaking to the sublessor that the said plot described in the third schedule hereof will not be used by the sublessee for residential purposes or any commercial establishment or any factory or workshop or for any purpose other than the manufacturing of electronic items. This was the agreement between me and writ petitioner.
And
please come to paragraph 4.
Read the previous paragraph also.
Yes.
Read the previous paragraph.
And whereas the sublessee has applied to the sublessor for sublease for a term of 90 years of one of the plots in the said industrial estate, fully described in the third schedule, hereunder written for the exclusive purpose of setting up of an electronics industry.
That is the purpose.
Yes.
That is the purpose.
100%.
Now tell me.
Just give me 2 minutes. Just give me 2 minutes.
Very good, sir. Very good.
Please come to internal page 6. Internal page 6 of this document. That will be
running page, sir. 26.
Just give you a lot.
26.
26.
Yes.
This is an agreement between Milord Webel and Ishani. Provided always that if there is any breach of any of the terms and conditions and covenants herein on the part of the sublessee, that is Ishani, that is the writ petitioner, contained, the sublessor shall call upon to rectify and remedy the same within 3 months of the date of receipt of such notice. If the required rectifications or remedial measures are not carried out within the given period, the sublessor shall have the right to re-enter into possession of the demised premises or any part thereof in the name of the whole, and thereupon the lease shall forthwith stand determined. Now, my lord, what this sublessee at page, my lord, 54 of the writ petition wrote to us, kindly see.
Yes.
My lord, by referring to, now first is, you know, this is an unimaginable stand that they don't know about their own MOU. Unimaginable stand, page 55. Be that as it may, they have sought for rectification. Now, what have they sought for rectification? Please see, it is furthermore stated, page 55 bottom. They themselves say, I commit a breach, and I say, in order to prevent breach, it is furthermore stated that we, the shareholders, upon conduct of the meeting, have come to that pertinent steps ought to be taken to prevent such violation of the express terms. Who is writing? The violator is writing. The
invoke 4.
Yes. Violator is writing.
So invoke 4.
Invoke 4. We have invoked 4. 4's invocation is page 56.
Does it say?
You know, it says,
what
does it say?
You are permitting them to carry on the
we are saying kindly take all possible measures in accordance with 3-4. You know, the language may be not impeded upon.
Not
the language,
so easy,
not the
sir.
sentence.
You are hereby therefore requested to complete the necessary formalities for entering into the development.
That language.
What is the development agreement for? Have you seen that?
With respect. You know, that development agreement is this 3494, if at all.
Have you seen that?
You know,
have you called for?
We have.
Then here there is a violation.
You know, wait.
Prima facie violation is there. I shall order.
You know, kindly.
Well, I have also, but I have
what is the violation?
Lordship,
You know, I put this question.
you
You know,
kindly
what
hear
is
me.
the violation? You know, kindly. Your lordship will not.
Violation in discharging your sovereign duty.
You know, what is the violation? When I put this question to myself, I have written in response.
You are permitting a person to utilize the leasehold land for a purpose beyond the.
We are not permitting. Kindly records my statement. We are not permitting.
Very good.
We are not permitting.
Yes.
Kindly, Mr. Mitra will just give me some more time. Kindly do not throw me out like this. Being the factual position, this letter is dated.
This code will not allow any construction there, except for setting up electronic.
So that is also my case.
You execute the.
That is also my case.
Will not allow.
That is also my case. Your lordship has not even seen certain documents.
Very good.
We have not cancelled. They are still our existing.
So you are agreeable to discharge your sovereign function.
100%.
Very good. Yes.
And this
Let me hear, Mr. Mitra.
This writ petition is violative of it is to be dismissed on other grounds. Not necessarily sovereign function or this your lordship has immense powers. I am not on that. But our writ court cannot be transposed to something beyond what the purpose of the writ court is. The writ court today is being
Very good.
utilized.
I'll keep the maintainability point open.
Milord, yes.
Yes, Mr.
Milord,
Mitro.
Milord, please see I, page 9, internal page 9 of the agreement. Please see. Kindly see. Milord, kindly.
Page 9 of what agreement?
Of that agreement, Milord, which I was inviting your lordship's kind attention. I read page 6. Milord, page 9 will be.
Please read.
Yes. Page 9 will be page 29. Now, please see. I, serial number I. Milord, I want them to adhere strictly in terms of I. Let them act. I have no problems.
Should we record that? I don't have any.
I want them to act. That is my case. What? Milord, this language, yes. Milord, I was telling Mrs. Ghosh also, Milord, this, they have violated. The violator is coming to your lordship.
So exercise your option of right entry. Right of entry is there.
You are there. Milord, what has been done? I am only saying.
I understand your contention. Let me hear, Mr. Mitru.
And Milord, regarding the arbitration, regarding the all these things have not been disclosed in the writ petition.
I am not concerned about that. Yes, Mr. Mitro.
Lordship, kindly come to my application, page 80, page 253. 253. Towards the very end, last 4-5 pages.
But first I want to see the development agreement between you and
The development agreement is at page.
I want to see.
That is at page 11. It does not say for residential purpose.
Let me see.
Page 11 of the camp. I'll commercially exploit. I'll bring.
What is the purpose of the agreement?
For commercially exploiting. It doesn't say for what.
For what purpose?
We will do IT related
Mr. Mitro,
services.
please be specific to my question. Whether it is for setting up industrial complex?
This is for development. This does not say for what purpose.
Then it will go.
Well,
No, sir.
Kindly come to page.
Take down,
page 180.
Please take
it. Page.
Sir, Mr.
May I show
Mitro,
one document?
Mr. Mitro,
Yeah.
I want a specific answer from you.
Yes.
If you can.
I will do it only for industry.
Mr. Mitro,
I will
listen to my question.
Mr.
Mr. Mitro, you have to answer my question. Whether the development agreement is for setting up electronic complex or not.
We will
If it is
set up.
yes,
We will
if
set
it
up.
is yes, it's all right. If it is no, I'm passing order.
We will set up only electronic.
Show.
Page.
Show me the relevant portion.
Kindly come to page 181. 181.
Mr. Mitro, I want to see the development agreement was entered into only for setting up electronics complex. I want to see from your agreement itself. First, so then I will go to any other place. Sir. I'm sorry, sir.
May I place my case? May I just
No,
place my
sir,
case?
I will not allow you to
Place my case. I have my
Answer to
application.
my question, whether the development agreement was entered into by and between the petitioner and your client for setting up any electronic complex or not.
Well, my agreement is for a future development agreement to be registered. Lordship kindly comes.
No, I will not come anywhere.
Lordship kindly hears me at least. I want to show 3-4 pages.
I'm hearing.
Well, page 189.
Sir, you are.
Kindly see 181. Kindly
You
see
are
page.
going to utilize a public land.
No,
Purpose,
whatever
other than the purpose it was let out.
permission given 181 by the municipal by the Department of Technology. Lordship kindly takes a look at
I will quash that order. It was not originally set up.
page 181. Kindly takes a look at 181 of the application.
Yes.
Webel, right? This is a letter from the government to Webel with reference to your letter number so and so to various companies at Sector 5 Salt Lake. I am directed to certify the name of the companies mentioned below have been found to be entitled for exemption of holdings used for information technology and information technology enabled services under section 102B of the West Bengal Municipal Act. The premises mentioned have more than 50% space occupied for ITS. Kindly come to right hand, Ishani Electronics. So permission given for electronic enabled services. Electronic enabled services. And my prayer in the present application. And my prayer in the present application. Kindly see my prayer. My prayer is prayer C. Respondent authorities be directed to grant necessary permission to the applicant for carrying out development of subject property in terms of the prevailing policies in this regard of the respondent authorities as and when applied for.
The cabinet has taken a decision. The cabinet has taken a decision that this land will be used for commercial purpose other than electronic purpose.
My lord, page 253. The UDMA's decision. The order of UDMA of 3rd June 2008.
Yes.
253. Fourth paragraph. Second paragraph. Of late, WBIDC has received a number of proposals for sublessees seeking permission to transfer the subleased land to other entrepreneurs. WBIDC refers to the proposals to UDMA, scrutinizing the project and reports. Now, Lordship, kindly comes. Fourth paragraph. After careful consideration of the matter and in order to expedite the disposal of the cases, the government in the Urban Development Department has suggested to WA to follow the procedure for allowing such proposals for transfer of subleased plot. Kindly come to Roman 2, last 5 lines of this page. In this regard, basic policy decision of the government in the Urban Development Department not to allow more than 20% of total built-up space of an ITS industries for commercial activity should be strictly followed. So 20% for commercial and the balance 80% for ITS. I am asking for permission to follow this policy and to develop this land. Now, Lordship, kindly comes to page.
Give me a second. Mr. Mitro.
Now,
Mr. Mitro,
yes.
Read clause 2, first line.
Such transfer proposal shall not involve a change of use from industrial to commercial. In case of any change of use from industrial other than ITS, admissal fee for change of use shall be collected by WBIDC in the form of bank draft. And after processing the matter, the particular change of purpose may be sent to this department for formal permission, along with a demand draft in favor of the Urban Development Department. But apropos this, kindly see my averment at page 7 of my application. Kindly see page 7 of my. So this is permitted. Now kindly see page 7 of my application.
Yes.
Paragraph 19.
Yes.
From the permissions which have been caused to be obtained by the applicant for various authorities, it would be evident applicant intends to develop the subject property by constructing a building there for setting up ITS electronic industry. This would be evident from the documents annexed to a statement of claim. Now, Lordship, kindly comes next document, page 234. 234.
What is that?
Page 234. This is paragraph 11, last paragraph of page 234. The Webel, this is where is he keep making this case? The Webel is the original lessee of the said premises by virtue of lease is executed between Government of West Bengal and Webel for 999 years. It is imperative to mention here Webel has sublet the said premises for the remaining period of the lease in favor of respondent being the sublessee right there for the very specific purpose of setting up electronic industry as abbreviated in the terms and conditions along with specific undertaking not to use or utilize the said premises for any other purpose other than setting. It is important to state that here that in that it is on such ground of restriction that the claimant is barred from enforcing the MOU. This is their case before the arbitrator, page 231.
Mr.
231 it starts.
You are showing many things, sir. But why are not showing the purpose of the development agreement?
I have the development.
It's not a civil court.
Civil
In
court.
a civil court, you are to plead, and unless you plead, you will not be permitted to adduce evidence. But in a writ petition, the subject is something different. You have to plead and you have to adduce evidence. What is the evidence? I want to see the development agreement. I want to see the agreement as has been executed by your client or the writ petitioner, where it has been stated that it was the purpose of the development that I intend to see.
But it is not Lordship kindly sees that the document at page
Enough,
11.
that's all.
At page 11.
Evidence speaks.
The development agreement is yet to happen. Kindly see page 11. Kindly see page 11 of my application. My MOU is there.
I will give you enough.
My
enough
MOU
chance.
is there.
Very good, sir.
MOU says development agreement will be executed in future.
Very good. What is the purpose of MOU, sir? That I please show me.
Well, I am going to show. Well, on the page 11, Lordship kindly comes to. Well, Lordship asking for that. Lordship kindly comes to. কোথায় গেল ওটা? At page 14.
Yes, বসু.
Clause 6 on top. It is yet to happen. Sublessee herein and the developer herein agree and accept subject to strict compliance of all terms to the MOU followed by a formal registered joint venture development agreement. That has not yet been done. That's my prayer before the arbitrator. So I am saying I will execute this this is in the MOU. So I will do this development agreement strictly in terms of the lease and the extent policies. So this is the development agreement is yet to happen. And see my prayer before the arbitrator. My prayer is for execution of a development agreement. And he has said, I have a development agreement for residential purpose. Now she kindly sees my prayer before the arbitrator. Arbitrator, my prayer is page 75. I have asked for execution of the registered development agreement. Kindly comes to page 75 at prayer, which one? Prayer, page 76.
Page number 23, sir, is it for, these are for setting of electronic complex?
But that will be stated in the development agreement. And I have asked for development agreement. They have only asked for permission. They have asked for permission for development agreement to be executed.
Court can mold the prayer, sir.
No, not even a prayer.
Court can even mold a prayer.
Mold.
Yes, sir. Court can. Court can.
You are just wondering. This is wholly, kindly indicates one sentence. This is wholly without prejudice to our rights and contentions.
একটা line after দিন, it is we will not do anything. I'm telling
Let Webel decide what Webel is going to do. If they decide something again, we will have something to.
we are welcome, sir. We are welcome.
The more they do, the better for us as lawyers.
Oh, sir, I'm requesting. Sir, I know Mr. Bhattacharya, but I do not know Mr. Bhattacharya's client. But Mr. Bhattacharya's client's letter, basically the second paragraph, is sufficient to prejudice a court. May I repeat? দাঁড়াও, এই তো শেষ
চিঠিটা কিছু করেন
এখনো গেলেন না মারুতি
Your lordship has not done anything with the letter. Letter stay করেছে.
But that will not prevent you to take appropriate.
Second part needs to be not the entirety of the letter. How can you the first portion is different?
I have not passed any order, sir.
So No, one sentence. This letter, the entirety of the letter cannot be stated.
No order has been passed with regard to the letter, sir.
Very well.
Wait, Mr. Bhattacharya. I told you I know Mr. Bhattacharya. But I don't know Mr. Bhattacharya's client.
One sentence, the letter to that extent may be stated.
Listen. No. Again you? Why? Come after vacation. Come after vacation, not so urgent.
No, my lord.
Let
Urgent
the
matter, my lord.
huh?
Urgent matter, my lord.
Why urgent? What is the
Kindly
urgent?
take up the hearing.
কি urgency আছে বাবু?
My lord, possession till now not handed over, my lord. I'm placing my lord.
My lord, I have got the report, my lord.
Yes. So first submit the report. Yes, Mr. Chakraborty.
My lord, and auction was floated, my lord, in the year 2017. On 26th May 2017, petitioner participated in the said auction process and became the highest bidder, my lord. Petitioner initially deposited 1/3 payment, but full payment has been done as of now, my lord. EC was granted by the District Environment Impact Assessment Authority on 27th November 2017. my lord.
What has been granted?
Environment clearance, my lord.
Environmental. Very good. Then
My lord, the lease deed was registered. The lease deed was executed on 25th February 2021 and thereafter registered on 18th June 2021. my lord. Petitioner made application seeking environment clearance, seeking possession before the ADM DLRO. The ADM DLRO, my lord, directed the Block Land and Land Revenue Officer to hand over possession on 25th May 2022 at page 86. my lord. Kindly see.
page number 86.
Yes, my lord. But the concerned Block Land and Land Revenue Officer is still date did not hand over the possession to him. Complete inaction and violation of the order of the superior authority, that is the additional district.
Why not doing, sir?
Not handing over the possession till now.
The report says that, my lord, the page 86, that within 3 days the possession was directed to be given to the petitioner. The petitioner remained silent for 1 year.
Not remain silent, my lord. Made several representations, my lord.
Representation on 24th May 2023 and thereafter in 25. He also remained silent in this matter.
I never remained silent, my lord.
Oh, no. After receipt of this letter on 25/5/22, what you have done?
My lord, the action has not yet been taken.
What your BLRO has done, that I intend to know. Then ask your BLRO to remain present. If he is so honest, if he is so diligent, he ought to have issued a letter to the writ petitioner that you come and take possession.
Take position, yes. My lord,
He has not done anything.
my lord. But the petitioner is also negligent. My lord.
No, my lord.
Petitioner is also negligent. He has not, my lord, pursued his matter.
Sir, for the negligence of the writ petitioner a writ does not lie. But for the negligence of an authority, a writ lies. Then, sir,
Let the, my lord, the BLR be pursued present. I have, my lord, after vacation, my lord. BLR is to let the, my lord, the report.
grievance of
Yes,
That is 5 years.
kindly, my lord, mention it or else they will not issue.
ও বলেছি না কি লিখলাম
প্রফেসর সাহেব পাগল করে দেবে। Life of the petitioner, my lord. Lord, the petitioner number. Now file to the. Lord, the petitioner number 1 is a professor of a college, and the petitioner number 2 is my lord. বলা আছে প্যারাগ্রাফ 5 এ বলা আছে আমি জানি।
Highways Act.
Yes, Lord, the difficulty is, Lord, as I said, Lord, the petitioner number 1 is a professor of a college. His wife, petitioner number 2, is a school teacher. After retirement, they wanted to build a house in a place, Lord, in the rural area. They bought the plot. Then after that, Lord, they have mutated everything. Suddenly, Lord, 2% Lord comes and makes out the unauthorized
private
construction.
respondent.
Private respondent, Lord, I have, so the writ petition that came undelivered, but the notice for mentioning for upgradation that has been delivered. Your lordship would kindly peruse this, Lord. I have folded it for your lordship's inspection, and this is the affidavit of service in respect of the writ petition that has been delivered. দিয়েছি।
Manu and Osit.
Lord, yes, these are the 2%, and your lordship, to give an idea, Lord, I have just taken a photograph of that particular area. I have also annexed. Your lordship would kindly see. Now, Lord, whenever I am going, I am facing inconvenience and taking advantage of my social stature, Lord. I have been put to trouble, and I have been also, Lord, humiliated and being, lordship knows, Lord. I have explained to my learned friend what is happening.
Any report, sir?
I'll have to take instruction.
What?
Yes, Lord. Kindly come to their representation.
Where is that?
Difficulties.
At page 37.
Difficulties. Those 2 persons are not mentioned as the number. Oh yes, subject under the heading of subject. Ochit Das and Kanu Bhattacharya. Both are residents of
36.
Ramchandrapur. One are kindly direct the authority to.
The service is affected.
Kindly direct the authority to take the steps under West Bengal Highways Act,
Section 10.
giving the 2 private respondents a notice.
Mr. Banerjee is your junior.
Yes.
Yes.
Why are you not allowing Mr. Banerjee to move?
My lord, as I said,
The last occasion, Mr. Banerjee.
he has secured an order.
Very well.
I have secured an order, my lord. I am carrying the order also, my lord. As I said, my lord, the first opening word was the petitioner number 1 is a professor. My lord, that's my personal
Special
difficulty.
request.
My lord, I can't help it.
I understand. Don't worry, I'm there just saying this lightly.
I was requesting him to do it. And
Because
because I've got the order.
And on the last occasion, I troubled him very much and was able to point out all the questions.
But he has also drafted this petition and he is acquainted with the facts also. And I have also got the order for your lordship.
The affidavit of service is filed today.
My case, my lord, it is 60 days.
Very good.
Obliged,
Where do you live?
and myself, lord, in Kalikapur, Anandapur police station.
Far away from his residence.
But he comes regularly to my chamber.
You reside at Uttarpara?
Bali.
Bali. Amen. Some encouragement for junior is required.
Indeed, indeed. But I said that you will do it, but he said no, you. And lord, the professor.
Be courageous, but don't be reckless.
My lord, I am appearing for the petitioner.
Long time.
Yes, my lord.
I appear on behalf of the writ petitioner after a long time.
After a long time.
Good case or bad case?
My lord, in my opinion, my lord, good case.
Good case. Let me see.
My lord, here I am challenging the order passed by the BLLRO. That is page 63.
Gaya. Go to the tribunal.
My lord, if your lordship decided the issue, if entire process is without any entire process, decision making process of the authority can always be a subject matter or challenge before the writ court.
In a mutation case?
Mutation case, decision making process. My lord, the BLRO decided the issue against dead person. My lord, the defendant in which my lord, the BLRO decided the mutation case against dead person who has died, my lord, in log 1985, and without making me as a party. My lord, I am the possession since 50 years. I am the purchased property by way of deed, and my lord, without any, my lord, kindly see for a moment. My lord, kindly see for your lordship already decided the same issue, my lord, in my case.
Madam.
And one notification. My lord, one notification kindly, my lord, in favor of me, page 77. Kindly see for a moment. Page 77, that is government notification. My lord, this is decision making process against dead person. My lord, who has already died, my lord, without verification. My lord, kindly see for a moment what type of order passed by that BLLRO.
Very good.
My
Let
lord,
him pass.
kindly see for a moment. My lord, this is my satisfaction only. My lord, page 64.
The subject matter of Appeal, go file an appeal.
Next,
Next.
My only, my lord, humble prayer before your lordship, the petitioner already
Very
filed
good.
an
Asun.
appeal before the appellate
Very good.
forum, my lord, that can be disposed of.
Puja vacation, and after your lordship's getting single bench, this is my first appearance. I got no, before the division bench I appeared. Under challenge. Give me a second, sir. That is very short, my lord. West Bengal Highways Act. National Highways Act. National Highway or West Bengal Highways Act? National Highway. Who's for the National Highway Authority? You.
I'm for the state, my lord. National Highway Land and Traffic Act 2002, my lord. One notice was sent, my lord, by the executive engineer.
Nobody is appearing on behalf of the NH authority. Where is the service? Yes, my lord. You have not made any private respondent party? Yes. So there is no private respondent, my lord. Only National Highway Authority. My lord, what's happened? Who has made the encroachment? No. My lord, I. Read petition. Allegation against me. My lord, I have the land in the close vicinity of the highway. And over my property, it may extend to the highway. I am not denying that. But I have a tea stall. My lord, at the bus stand, my lord, there are so many tea stall, other shops, etc. But only I have been chosen to issue the notice. And I had been served the notice as page 19. And how the notice had been served, kindly have a look once. Page 19. My lord, the notice is issued on 12th of August 2025. Page 19, my lord. At the top right hand side. 12th of August 25. And my lord, kindly come to the last paragraph. Hence, the notice is hereby served to you to provide you chance to appear this office on 19th of August 25 at 12 p.m. My lord, kindly come to next page. The day when I had been served the notice asking me to appear on 19th, but the order had been passed on 12th. Not page 20. Notice for removal of unauthorized occupation. Last line. Issued under my hand and seal at Kharagpur on 12th day of August 2025. Page 19 says, 12th August 25, notice was issued. I had been asked to appear before the authority on 19th of August. But the order for removal is passed on 12th of August. Then what happened? Then, my lord,
You're praying for quashing of this letter?
Yes.
This order?
Yes. This notice. 12th August, I have been issued the notice asking me to come and appear on 19th.
As of today, my lord, they are in possession of that property. my
Yes,
lord.
yes, yes.
Now the BLRO is proceeding for demarcation of the land.
Yes.
What I have instruction I have got from the executive engineer. my lord. Because they have admitted at the time of hearing that they have encroached.
Sure.
My lord, may I hand up the this?
ওটা দাও আমাকে আর কপি দাও
What is the service upon the NHI authority?
Yes, my lord. I have handed over, my lord. এক্ষুনি আপনি যেটা সিঙ্গেল দিলেন জজ সাহেবকে
Executive engineer. Why you have not served the
my lord, the notice issuing authority had been served. Executive engineer, National Highway Division 2, PWD Roads Directorate.
affidavit of service?
After vacation also, I will not remain tomorrow. Not, only
My lord,
came the
এমনি আমরা
27 after vacation, Lordship, I consider.
My lord, before your lordship rises, my lord,
One, my lord. So I pray.
before your lordship rises, my lord, I beg your pardon that I'm mentioning at this hour, my lord, but there was a leave granted by your lordship yesterday to add the assistant engineer in this matter, my lord. But I could not get my advocate on record back then. He's a 76-year-old man, my lord, with heart diseases. Today only I've had the privilege of having him in the court, my lord. So kindly gives us today, my lord, and keeps the matter after vacation, my lord. I did not appear, my lord. My learned friend was appearing. My learned friend, Mr. Rai, was appearing in this matter, my lord. My lord will kindly remember that I was appearing in this matter.
27 also, my lord.
At item number 17.
Then after you look to the other side, took the time. Last day, that's why I'm playing.
My lord, if the leave can be extended for today and the matter be taken up. দাঁড়াও না রে বাবা
After vacation, but I am but the stay.
নামটা বলুন
শেখ আব্দুল্লাহ মন্ডল। শেখ আব্দুল্লাহ মন্ডল।
আব্দুল্লাহ তুমি নিজে তো সেটা বলবে তো
ওই তো বলতে
kindly appreciates the difficulty, my lord, keeps the matter after vacation.
I am but the stay.
My lord, this matter can be taken after vacation, my lord, because today is the only day. কি করতে বলবো